So that's my plan. I'm gonna go to housing after here, then I'm gonna go to my meeting.
Good morning.
Then I'm gonna figure out what to do.
I'm Senator Julie Kushner, and we are going to convene this public hearing for the Labor and Public Employees Committee. And we will start right away. Before we start, I would like to ask if Ranking Member Sampson would like to say anything.
Thank you very much, Madam Chairman. I appreciate that. Just wanted to let folks know that are watching today that a number of us are in multiple hearings and meetings today, including myself. I'm the ranking member of the Housing Committee as well, so I'm going to be bouncing back and forth between both rooms. So just please know if we're not up here for some reason that it's not because we're not listening or not paying attention to what's going on. It's just that sometimes it's difficult when you have multiple meetings going on. And I look forward to a productive hearing. Thank you very much, Madam Chairman.
Thank you, Senator Sampson. And that goes for all of us. I will be stepping out a few times today for hearings as well. And I see my co-chair, Representative Sanchez, is on Zoom. Would you like to make some opening comments?
Thank you, Madam Chair. I am isolating right now. I have COVID, but look forward to hearing testimonies today. Thank you.
Thank you. And we hope you're feeling well and will quickly improve and be back to us as soon as you're done isolating. So thank you for being here today. Would either of our vice chairs like to comment?
Thank you, Madam Chair. Just looking forward to the meeting, and I too, like many of us, will be bouncing around, but I'll be as engaged as I can. Thank you. Looking forward to a good hearing.
Okay. And Representative Ackert?
Just ready to get to work, Madam
Great.
Chair.
Great. Okay, then we'll begin. And I see Representative Gilchrist is here. Good morning.
Good morning. Good morning, Senator Kushner and Sampson, Representative Sanchez and Ackert. Representative Sanchez, I hope you feel better soon. Thank you for the opportunity to be here and for bringing this bill for a public hearing. I'm here in support of House Bill 5290, an act concerning state employees and equitable holidays. This issue got brought to me by an individual in West Hartford who has worked for the Department of Children and Families since 1998. And since that time, she has used more than 65 personal days to observe Jewish holidays. So while it is important that the current law is explicit that employees can use personal time for religious observances, the current policy does give preferential treatment to Christian observances, which are provided to state employees as paid holiday time in addition to the personal time. So Connecticut has 12 state holidays, 2 of which are Christian holidays, Good Friday and Christmas. And for the employees who recognize these 2 holidays, they get paid time out of work without having to use their personal leave. So I'm requesting that the Labor and Public Employees Committee vote to establish an equitable holiday policy whereby state employees can swap out at least 2 current state holidays for religious observances of their choosing. Delaware, New Hampshire, and Texas do offer their state employees flexible holiday policies. And although they vary, these states give employees a choice over which paid holidays they take. Connecticut's policy shouldn't be too prescriptive because we want to avoid requiring multi-faith families to swap out one religious holiday for another. I propose Connecticut offer full-time state employees at least 2 floating holidays per fiscal year, which must be used as whole days within the fiscal year. The goal is to keep the policy cost neutral. Employees would not receive any additional paid time off because they will take the holidays of their choosing in lieu of a current state holiday. When this bill was raised previously, the biggest pushback was what would folks do, like if they were going to work on Christmas and the state building is closed. But since then, we've experienced a pandemic, and remote work has become a regular thing that we're all used to. And so I think there are solutions that we could employ. So that's pretty much the proposal. Would love your support and happy to answer any questions. Thank you.
Thank you, Representative. Any questions or comments? Representative Ackert.
Thank you, and good to see you,
to see
Representative. So yes, you teed me up a little bit there with that proposal, because, I think that in many of our jobs that are out there, the key concern would be that somebody that can remote work, this would fit them and be beneficial. But I look at DOT, DMV, multiple ones like that are in person. That would say, hey, what about me? I mean, I'm scheduled, to work, and listen, we want to make this if we're going to make it equitable, we can't exclude those that don't sit at a computer, which is a good portion of ours. And then if they're a service orientated person that, accepts calls or whatever, and the office is closed, this building gets closed, things like that. So that's the hurdle that I'm struggling with.
Yeah.
Not the fact that we shouldn't think about others that observe other holidays than a Christian may. So that's the thing that I'm trying to balance now. And I always know that, knowing so many of the commissioners that we have that already struggle with workforce, how did they, make it so that they have work that they can do while the typical business hours are closed. So if you have any thoughts on how those individuals that are out doing the road work or out doing the others, how would they be able to fit this?
I think, it's worth the conversation, and I wonder, are there shifts that would be taking place on holidays? And so for those employees who would like to swap out, is it then possible that they'd be the ones to take that day? Not be forced to, but just really facilitating conversation within agencies. To the workforce piece, I mentioned the Jewish holidays, but there are many faiths in this state. And so I think it actually could be a policy that supports the workforce and recognizes that we appreciate them, and maybe attracts folks to state work.
And just another thought, I know that we primarily, all of us supported Juneteenth last year. Whenever we did it, we supported that. And at that time, I had thought about, well, why don't we swap we have two presidents, holidays, to be honest. Like, why don't we say, let's eliminate the president's holiday and actually have a Jewish holiday that is a regular state holiday, or another one, or something along that line, that we can be more flexible where something along that line. So just a thought is that the state stays a little bit more open, but it's a great dialogue that we should be having on this. And I thank you for raising the awareness to this.
Thank you.
Thank you. And thank you, Madam Chair.
Thank you. Just one suggestion, if you could maybe check in with some of the states that have done this, and that would be helpful for us to know how they handle similar
Okay.
issues that were raised by Representative Ackert, because every state's workforce is, very similar. So they probably have had to deal with that, and it'd be helpful to know how they handled that issue. But thank you very much for your testimony.
I'd be
today.
happy to do that, and I'll follow up with the committee. Thank you.
Thank you. Next up, we have Senator Martha Marks. And I don't see her in the room, so we will move to Representative Jamie Foster, if she is in the room. I don't see her as well. So next up, we have Senator Berthel.
Madam Chair, I hope the rest of your testimony goes as quickly today before the committee. Good morning. Chairwoman Kushner, Chairman Sanchez, Ranking Member Sampson, Ranking Member Ackert, and distinguished members of the Labor Committee. I am here today to testify in support of Senate Bill 831, an act concerning amusement parks and the employment of individuals at least 14 years of age. I thank the committee for raising this bill for consideration. And I have with me, if you'll indulge me, I have George Francis, who is the owner of Quasi Amusement Park in Middlebury, one of the oldest amusement parks in Connecticut and actually in the nation, multiple generations, who I would like to yield my time to let him explain to you why this bill is so important and should be considered for ultimately a vote, and wouldn't it be great to have the governor sign it? So, Madam Chair, if I may yield my time to Mr. Francis. Thank you.
And Mr. Francis, just please, when you just state your name again for the record.
Yes, my name is George Francis. I'm the owner, one of the co-owners of Quasi Amusement Park located in Middlebury, Connecticut. We're celebrating our 115th year of operation in the state proudly, by the way. I've submitted a letter regarding my research into the bills or the laws that exist now as far as labor is concerned. And there are some ambiguities that I think, or sort of, let's say, gray matter that I think has made it difficult for me. In the past, we have been able to employ 14 and 15-year-olders, and about 20 years ago, maybe even 15, as far back as that, until a labor enforcement officer came and said, you can no longer hire 14 and 15-year-olders. To my question was why, and to their statement was because you're in a hazardous work environment, and so I proceeded to ask what that really meant, and basically it came down to that there's machinery around where these kids would be working, and I said, but I have retail establishments, I have clerical, all the things that are legitimately viable job performance areas where these kids can work. And his comment was basically, well, an amusement park is considered a hazardous work environment. If you had a Quasi amusement park retail store business and they were receiving a check from that department, then by all means they could work. So, you know, at the time, labor was pretty fruitful, and I said, okay, and we no longer hired 14 and 15-year-olders, and we moved on. In today's world, obviously, with the labor shortages where they are, and everybody grasping for employment or people to employ, I just thought it'd be a good time to revisit this thing. And conversely, as far as our businesses, us and Lake Compounds, who we are hand in hand, unfortunately, they're in the middle of a transition as far as management is concerned. So I don't have my partners with me in crime, but we consider ourselves educators. And, you know, we take these young adults and we get them out of sitting at home playing video games, and we get them out and we teach these kids responsibility, time management, how to interact with people in today's world. Get off your phone and do things. We follow all the regulations for hiring these young kids, timeline of when they have to be home by, the amount of hours they have to work in a given week. So we have all the parameters that I believe we follow very well to I think revisit the ability to hire 14 and 15-year-olds. And so that's why I'm in front of your committee again to support the bill 831 and answer any questions do you think that might be pertinent to make this come to fruition.
Thank you. Are there comments or questions? Representative Ackert.
Thank you, Madam Chair. And thank you for being here again, because I know we bumped it to 15, didn't we, in the past?
So Representative, I think 2 years ago, the committee took up and passed a bill that allowed for 16-year-olds under proper supervision and training to operate amusement park rides. That was the bill that we successfully passed. And I think Mr. Francis, if the committee is so inclined, can speak to an operating day this past summer where if not for the provision of that bill, he would not have been able to open the park. He didn't have enough 18-year-olds, which was the limit before.
Okay, that's those operators. I knew there was something. We've been working on amusement parks for a while.
We have, yeah.
Eric
We tried last year for
taking
this.
He's
Thank
been
you.
doing his job, even back when he was state rep, when it was.
Thank you, Representative.
But just, that's okay. You don't need to indulge in that. So, but I appreciate that. I was trying to file if it was the retail portion of it. So it's still 16 that can work at a concession stand type of thing?
Well, quite frankly, there's a lot of gray matter. And if you read through it, it says, you know, has amusements are a hazardous work environment. And then it says, see section I'm paraphrasing 3B. And you go there and it just goes into the hours and the standard formats that we could easily follow. And so I think the problem with this is it's pretty antiquated law. And back in the day, when carnivals would come into town, the ticket booths or a lot of the concessions were right next to a ride and thus near machinery. And that's, I think, where the exclamation point comes into play. Whereas if I could subsidize, again, because being able to utilize the older kids in the proper locations and subsidize 14 and 15-year-olders, get them in, my dad used to say, get the camel's head in the tent, the body's going to follow. And so if I could get these kids to start off at these menial clerical tasks, maybe selling tickets or clerical work or in my retail stores, and then cultivate them. I could have these kids for 3 or 4 years and really develop hardworking kids with some work ethic.
So the catch is it's amusement park is what's the holdup is.
Quite frankly, yes.
Thank you so much for being here. I'll review that. I'll work with the attorneys and work on that, take a look at it. So thank you for being here and thank you again, Madam Chair.
I greatly thank you for giving me the time.
Thank you, Representative Wilson.
Good morning. Thank you for coming again. Just a small question. So a situation like this where if the bill was to move forward, how does it affect, how many individual employees do you see yourself possibly employing in an instance like this?
That's a very good question. And again, I think if you broaden the horizon, so to speak, to even like compounds, it's not a significant number, but it's a great tool for training and grooming. And, I can only speak for myself, but I'm looking at maybe a dozen or two positions within the park that could free up another dozen or two older kids to do the more hazardous tasks that are at an amusement park, which I think are pretty nominal anyway.
How many do you hire seasonally?
The question was, how many students do we hire seasonally? Last year, I think we were over the 400 or 500 range.
And actually, that was the next question I was going to ask. So thank you for that. The last question I would have is, are there other states that already kind of have it in this where they allow this
Great
age
question.
range?
Connecticut, in my research, is the only state that doesn't allow 14 and 15-year-olds to work at an amusement park. And because I also have a letter submitted from which we're members of, the New England Association of Amusement Parks and Attractions. And in my research to find out just that question, they couldn't come up with one.
Thank you.
Thank you.
Thank you. Seeing no other questions, and we thank you for your testimony here today.
Thank you, Madam Chair, and thank you to the committee.
Next up, we have, State Representative Gonzalez. Good morning.
Representative Gonzalez, your microphone is off.
Oh, I'm sorry, I didn't notice. I'm here today to testify in favor of House Bill 5464, an act concerning complaint against state and municipal employees. The reason I'm supporting this bill is to require a record of complaint and or investigation of a public employee to remain on record if an accused employee decides to retire or quit before a full investigation is carried out. Currently, an active case does not continue to remain on an employee record, with the result that the person can then apply for public service in another capacity or move around with the same capacity. I personally know of cases, and an example of a related case in someone accused of sexual misconduct as an educator. that person was able to move around to different job location in the education field because their record was not disclosed and did not follow him, putting other students at risk. This practice also put all of us at risk because people can move around, for example, to a public safety capacity without having the record become part of the interview process. This does not give an interview enough information to make a true assessment with the possibility of hiring someone that does not belong in public service. I believe an accusation and investigation should be permanent and should follow the person as part of their employee record, no matter what public service job they apply for. We owe all this to the public, especially children, to do all we can to make sure proper decisions are being made when hiring people in capacity of public trust. Thank you all for giving me the opportunity today, and I'm ready for any question. Thank you.
Thank you. Any questions for Representative? Thank you for being here today.
Thank you. Have a good day.
You too. I'll be seeing you later, I'm sure. And next up, we have State Representative Rosario. And I don't see him in the room. So now we will move on to Kimberly Glassman.
Good morning,
Good morning.
Senator Kushner, Representative Acker, Representative Wilson, members of the Labor Committee. My name is Kimberly Glassman. I'm the
You
director.
do have Chairman Sanchez on there.
Chairman Sanchez.
I know you can't
Sorry.
see him, but he's here.
My name is Kimberly Glassman. I'm the director of the Foundation for Fair Contracting, and I very much appreciate the opportunity to testify this morning in strong support of SB 1035, which is an act concerning stop work orders. I did submit written testimony, so I will paraphrase and then leave time for questions. This is a pretty straightforward piece of legislation. What this legislation seeks to do is simply expand the applicability of a stop work order. The Connecticut Department of Labor's Wage and Workplace Division currently has the statutory authority to issue a stop work order if a contractor is in violation of maintaining workman's compensation. What the impetus behind this legislation that you have before you today is that in 2019, the state of New Jersey, and then last year in 2022, the state of Maryland, two states that look to Connecticut as a model, and said, we really like this stop work order as a way to thwart wage violations. And so what they did is they took our stop work order, but expanded the applicability. And in New Jersey, they expanded it pretty far into Fair Labor Standards Act issues, minimum wage, overtime. What the legislation before you seeks to do is just to expand that applicability to violations of prevailing wage. It also seeks to increase the fines and penalties. The fines and penalties have not been increased since the law's inception, and they're pretty low. No more than $100 a day, no more than $250 a day. That was really not going to be a deterrent. So we looked at both New Jersey and Maryland, and we're right in line with their fee, with their fine and penalty schedule. And so we've adopted that into the bill as well. Again, you know, my organization, we see a lot of wage theft issues in the public construction industry. We're always looking for ways to strengthen enforcement, give more tools to the Department of Labor. Certainly, this legislation does not mandate the Department of Labor has to institute a stop work order. We see this as a tool in their toolbox for very egregious violators who are not, who they cannot settle with. And so with that, I'm certainly happy to answer any questions. Appreciate your time.
Thank you very much. Representative Acker.
Thank you, Madam Chair, and thank you for your testimony and your description. So I got a couple questions. You may not have the information. This might be something that DOL with. How many stop work orders do we typically have in a calendar year that you're for wage?
Yeah, so last year in 2022, there were 33 stop work orders issued.
And they were on what basis?
That I cannot
Okay,
answer.
that's completely fair. I understand that.
But what I do know is that the majority of the majority of the contractors in which the stop work order was issued, the majority came into compliance within 24 to 48 hours. There was a very small percentage that did not come into compliance, and those companies actually, for a variety of reasons, just ended up folding and going out of business. And those are the companies that likely just didn't, weren't able to make their payroll, or didn't want to have to open a workman's comp policy because it would be, frankly, pricey for them. And they ultimately decided this isn't the state that they wanted to do business in, which is, I think, the goal of these stop work orders, is to weed out the good players from the unscrupulous ones.
And that would make sense that you'd want the bad actors. I'm unfortunately, in the construction field and deadlines right now. I had to work diligently yesterday to meet a deadline in an old construction project that I'm on yesterday, and worked very late. It does hurt the project itself, and there's no reason not to move this legislation forward, though. But I can see the hardship of the construction project itself. But again, if they're not paying the duly contracted wage, then I can understand that. And then so it's primarily for wage. How does prevailing wage not fit in the category now? I can see that's the section that's being added. I believe it'll probably be section 31-53.
Yes,
It's probably prevailing wage. How does that not fit under wages anyways?
It's just when the stop work order law was written, and I wasn't up here for that. So I can't speak to the legislature's intent with the drawing up the law, but when the law was created, it was created just for violations of workman's comp.
Just for workman's comp. Okay, that's very, very, very small component of it. So it's surprising that that many stoppages with just that being a narrow of an issue. Okay, and then we have legislation that we're working on now, which is adding wage inspectors. Because as you and I had a conversation, I think the biggest problem that I see in the state of Connecticut, being in the trades, is we know, listen, if you don't have the people to do the work, but we don't have licensed inspectors, we don't have other job type of inspectors and building inspectors for right now. We're so limited. And I think that needs to be addressed. And I've said this over and over. We have a lot of upper management, but we don't have the boots on the ground to make sure that we have a safe and legal workforce out there that's going on. So hopefully that somehow we can address that in the state. So I thank you again, Ms. Glassman, for being here, and I thank you, Madam Chair.
Thank you, Representative.
Thank you for answering those questions. I don't see any other hands at this time, but as always, you are well informed and keep us on top of our game, because I've asked you many questions along these lines, and you always educate me. So
And the
thank you.
Department of, I really owe, big thanks to our Department of Labor. They, they are experts in this field. So.
And I should add that I know they did file written testimony in support of this.
Oh, okay, great.
It was just filed and also added that there would be no fiscal note. So
That's
that's always good.
fantastic. Wonderful. Thank you.
Thank you.
Appreciate it.
Yeah, fiscal gain, yeah. Okay, next up, we have, let's see, let me just check the room and make sure that some of our legislators have not yet arrived. So we will move on to Mr. Joe Toner. Good to see you, brother.
Good morning. Chairman Kushner, Chairman Sanchez, Ranking Member Sampson, Ranking Member Ackert, and distinguished members of the Labor and Public Employees Committee. My name is Joe Toner. I represent 30,000 hardworking men and women in the unionized construction industry, and I stand in support of SB 1035. And following my colleague Kimberly is a little tough because Kimberly has facts and figures. So I want to be a little bit more descriptive of what's happening in the industry in Connecticut, the construction industry. And then it's not, and I sit here today and I am a building trades member. I represent the unionized sector, but I want to speak for all the sectors, for even the open shop contractors, the open shop workers. Connecticut has the weakest wage protection laws of all its neighboring states. So what's happening in Connecticut is all the bottom feeders that are being bounced out of other states are making home in Connecticut. And it's affecting everybody in the industry, not just our signatory contractors, but every contractor. Here's an example. Ferguson Companies was caught embezzling over $6 million through he set up a fake third-party administration company, and he was charging his members 10% of their wages and saying that it was going to a third-party administrator to administrate their benefits. So Mr. Ferguson stole $6 million of wages and benefits from his employees. He was sentenced for 18 months in jail. He did 6 months due to COVID and his age. So Lee Ferguson did a month in the jail for $1 million a month. That's not a bad gig, right? So when you're sitting around having a beer with your buddies saying, hey, what do you think? Would you go to jail for a month for $1 million, right? Well, Lee Ferguson grabbed $6 million and did 6 months in jail. And as of today, he's still bidding public projects in the state of Connecticut. Right? 20 years ago, he got caught misclassifying and extorting money from his members in New York, in 2 counties in New York. One was about 20,000, one was about 30,000, and he was debarred from New York. So Lee Ferguson Ferguson Companies is still bidding work in Connecticut. So when we keep trying to level the playing field for all of our contractors, it's disconcerting that these folks are still in the game, right? I'm an iron worker by trade, and I've been in the iron worker since 1988. And in the ironworking industry, what's happening is workers' compensation is $5 to $6 per man hour in the steel erection industry, right? So anybody working on the job, you're paying $6 up to $6 an hour on workers' comp per hour for that employee on the payroll. So we had a job up in Windsor a few years ago, and we had a company called A&D Welding from Georgia. So A&D Welding was the low bidder. We had RC Anderson. AC Anderson was a construction manager out of New Jersey. They took the job at cost. So when AC Anderson gets the job to construct the Amazon distribution center, they want the lowest number possible because they took the project at risk. So they gave them a lump sum number. We'll do the job for this number, and then we're going to give you the keys on this date, and then whatever in between, whatever they could put in their pockets, they're gonna, right?
Mr. Coner, your time is almost up. Please conclude your remarks.
So what happens is, just a long story short, A&D Welding, that was the third time they got bumped out of Connecticut. They got shut down for non-workers comp. But think about, there was 125,000 man hours on that job in the steel erection process. Think about the disadvantage for all our Connecticut contractors. They're at a $700,000 to $800,000 disadvantage because this person didn't provide workers' comp for his people, which in return, if they do get hurt on the job, they're in the back of the pickup truck going down to St. Francis Hospital. Once again, we're paying, right? So I just strongly support the bill. I just wanted to give you some real life instances that are happening in the construction industry, and thank you for the time.
Thank you so much. I don't see any questions, but I do want to say that your testimony is really helpful because you make it very real for those of us who don't work in the construction industry. And that's always important for committee members. So I appreciate your testimony here today. I know Representative Ackert knows all this stuff, but most of us don't work in the trades. And so it's very helpful. You're another good educator.
Oh, thank you.
Thank you.
Thank you.
Next on the list, we have Dawn Simmons, and I believe she's testifying remotely, and she is here. So Dawn, if you want to unmute yourself.
Hello, it's very good to be with everyone today. Good morning to the members of the committee and honorable committee chair. My name is Dawn Simons and I live in Newington, Connecticut. I come before you today in support of a proposed bill 6275. That's a House bill introduced by Representative Gary Turco. The use of employee private vehicles for employment purposes and adjustment of mileage reimbursement rates to the IRS levels. I am a merchandiser and I use my car to travel to work every day within Connecticut. My company and businesses like it are mostly foreign corporations doing business here in every state of the country too. These companies represent some of the largest and most well-known brands in the grocery industry, and most of them pay substandard mileage rates to their employees for travel. When gas prices increased substantially last year, I asked my company to consider raising their reimbursement rates, and they came back with a 3-cent increase. They said it was temporary while gas prices are high, and to give you an idea, that's like 30 cents a mile. This leaves me and other employees in Connecticut footing the bill for most of the wear and tear and upkeep and replacement of our vehicles. Let's be honest, when employees are asked to use their vehicles for work, this shields the employer from accident liability. So a higher reimbursement rate is not unreasonable, it is fair. Car prices are up astronomically in the last few years, and this makes the burden even greater. These companies make enormous profits off the backs of the working poor. Today, we need to send a message that this is not okay here in Connecticut. Connecticut did the right. I submit that we need to follow Massachusetts and the 4 other states that require IRS rates. Massachusetts is also raised the employment mileage reimbursement rate to IRS levels. My company pays this rate to 5 other states that require it. My company pays double to Massachusetts, our neighbor, in comparison to what they pay for Connecticut employees. This is not about charity. It is about paying what is fair and not allowing low-wage earners to be exploited. This is a simple way to offset the risk employees take using their own vehicles for business, and it will also help incentivize more people into the workforce. Owning a car is a great expense for the poor that often knocks them out of the job market if they lose it. I've seen it with coworkers. A few $100s of reimbursements means that they were able to pay for the expenses of their car as they occur. The good news is the mileage reimbursement expense is tax deductible to the company, but not taxable for the employee. So it is a win-win. And let me comment that a lot of these jobs are held by members of our African-American community. It's a win-win. So I hope I've made a clear and convincing case as to why mileage reimbursement rates in Connecticut should be increased to IRS levels. I thank you for your time and attention. I urge you to vote yes on House Bill 6275.
Thank you for your testimony.
Thank you.
Any questions? Okay, give me 1 second. I just want to check one thing. I'm checking testimony while we're working here. All right, if we have any other questions, I know we can reach out to you, but thank you today for your testimony. Really appreciate it.
Thank you. Honored to be with you. Thank you.
Next up, we have Brooke Foley. Good morning.
Good morning, Senator Kushner, Representative Sanchez, Representative Acker, Senator Sampson, and the other honorable members of the committee. My name is Brooke Foley. Thank you so much for the opportunity to testify before you today. I'm the General Counsel of the Insurance Association of Connecticut. The IAC represents Connecticut's property and casualty insurance industry, as well as Connecticut's life insurance and financial securities industries. The IAC would like to testify today in opposition to House Bill 6721, an act concerning workers' compensation and portal-to-portal coverage for telecommunicators, and House Bill 6272, an act concerning workers' compensation death benefits and the cost of living and inflation rates. And I've also submitted testimony on these 2 bills that I would ask you to please read as well. The first bill, 6721, would allow a dispatcher, whether employed by a public or private safety agency, to file a workers' compensation claim for injuries sustained on the way to work or on the way home from work during a regular commute. Under what is known as the coming and going rule, a worker injured during their usual commute to or from work is generally not entitled to workers' compensation benefits because the injury does not arise out of or in the course of employment, which is a basic requirement of workers' compensation law. Under several exceptions to this general rule, workers are already eligible to receive workers' compensation coverage if they are injured on the way to work. One of these exemptions is the emergency call exception, which provides workers' compensation coverage for workers injured while driving to and from work in response to an emergency call or at the request of their employer. This is already the law, and dispatchers are already protected if they're going in to work in response to an emergency. The Workers' Compensation Act was never intended to cover injuries that occurred during a normal commute to and from work, because such activity falls squarely outside the employee's employment activities. Expanding coverage to cover the everyday commute would result in an influx of claims, which would be extremely difficult to investigate and challenge, and it would compromise the integrity of the workers' compensation system and result in substantial increases in costs for employers. The IEC also opposes House Bill 6272. This bill would require workers' compensation death benefits to be adjusted for the cost of living and inflation. We oppose this measure because the general statutes already require this in section 31-306. For these reasons, we oppose these two bills. Thank you very much.
Thank you. Representative Ackert.
Thank you, Madam Chair, and thank you for being here. Could you briefly describe, because I believe I knew a worker that was traveling home, I believe it was home from work, but stopped to pick up a grocery item and then continued to get in a car accident. But if he had not picked up a grocery item, he would have been covered under workman's comp. Is that not correct from your understanding? And that's just all workers. This isn't just the port. This isn't just the, is that not covered?
I think it completely depends on the situation, what kind of employment the person had, what their job was. I mean, I wouldn't be able to make any specific call without looking at the facts of that particular person, where they worked.
Okay, because you had brought up the fact that if it's you said it's already covered if it's an emergency, like if, okay, I'm I don't know, maybe a utility worker, power outage, I'm getting called in for emergency response. I'm on the way to work. Something happens in whatever happens that by what you had mentioned, stated earlier, that would be covered.
Right. I don't know about the exceptions if they stop to go to the store. I can't comment on that. I can try to figure that out and report back to you.
No, that was just an example of that I'd heard that was covered. Maybe this is going back decades ago. So on the travel home, so to and from home, I thought at some level it was already covered. You brought up a couple items, but you know, me driving here to come to work, I don't think we have workman's comp anyway, so I should use that. If, you know, my employees coming and going to work, a standard company coming and going to work are not covered under workman's comp. Is that true?
Yes.
Emergency call comes in, whatever, then that type of work that if you're on an emergency basis, in this case, let's say this dispatch person gets called, hey, we're short, we don't have a dispatcher, it's an emergency, come to work. You're saying that that's already covered.
As I understand it, yes, under the case law that is highlighted in the testimony that I've submitted to you, yes, it should be covered.
Okay, but not standard work, you know, here's your regular hours, you come into work, you're at work. They leave work during the work hours as a work relation type of thing to go do something for work, they're covered during the work hours, of course.
I believe so, but I'm not positive on all the different technicalities on that.
Okay. Well, thank you for your testimony. Thank you for being here. Thank you, Madam Chair.
Thank you very much.
Thank you. I have one simplified question, because what we've heard a lot from dispatchers over the last several years is that they are interested in being treated as other first responders. And so I'm wondering if there are other exceptions beyond the emergency exception that applies to first responders.
I don't know of any specific ones. Like I said, I've just found on the one case that talks about being called in for an emergency. If you'd like, I can look into that and let you know what I find out.
That would be helpful. Thank you. Sure. Any other questions, comments? Okay, thank you so much for your testimony today.
Thank you.
And next up, I'm looking at my screen, and I think the next person that's going to be testifying is going to be testifying remotely, and that is President Ed Hawthorne.
Good morning, Senator Kushner, Representative Sanchez, and the members of the Labor and Public Employees Committee. My name is Ed Hawthorne. I'm proud to serve as the president of the Connecticut AFL-CIO, a federation representing over 200,000 working men and women in the state of Connecticut. It is on their behalf that I testify, albeit remotely today. We have several bills. You have my written testimony. I'm going to go over and summarize a few. HB 6462, an act concerning the recruitment of state costs attributable to low-wage workers. I'm so happy this bill is making another pass, because to me, it just makes sense. It's a sad distinction in Connecticut that we lead the nation in income inequality. We leave the poorest residents to deal with education gaps, health disparities, unattainable home ownership, and other hardships. Years of austerity and disinvestment have worsened inequalities and hampered our economic growth. This bill attempts to right the ship. It holds huge corporations like Walmart, Amazon, McDonald's, Target, and others that exploit our safety net in our tax dollars, and it forces them to pay what they owe. So we're talking about corporations that make billions upon billions of dollars, but instruct their employees to enroll in Husky, apply for food stamps, claim the earned income tax credit, and seek other child care subsidies and attain other methods of public assistance. If they can pay their CEOs what they pay their CEOs, and we all know the extreme amounts that they can afford to pay their employees a living wage so that the taxpayers don't have to foot the bill for their greed. Another one, and I know you've already heard from the experts with Kim and Joe, but I do have to say, an act concerning stop work orders, we're in full support of this. I always say, if a tree falls in the forest and there's no enforcement, is the law really doing anything? So we need more of a deterrent factor in this. And, you know, when workers are paid in cash and not put on the books, or paid off the clock, or prevailing wage isn't paid, we need more protection for these workers, because there are contractors out there, both union and non-union contractors, that pay their employees what they're owed, and they're competing in the same market with these unscrupulous contractors that try to cut corners to save costs and submit lower bids. We need to level the playing field. So 1035 increases the fines from a minimum of $100 a day to a minimum of $1,000 per day. The bill would also increase penalties for violations of the stop work order itself from $1,000 to $5,000 a day. Let DOL do their job, let them have some teeth behind it, and we are in full support of that bill. Also, just briefly go over HB 6720, an act concerning the state managerial employee definition for purposes of collective bargaining. Now, everyone should, if they're non-managerial, which this bill would target the non-managerial employees that just have manager in their job titles, but are not authorized to provide any meaningful supervision. They don't negotiate labor contracts, determine benefits, or make decisions about hiring or firing or disciplining other employees. They should have the right, if they choose to join a union and be part of the collective bargaining that goes on with CBAC. Thank you for your time and attention. I'm sorry I can't be there in person today due to some family things going on, but I'll be happy to answer any questions.
Thank you for your testimony. And I don't see any questions at this time, but thank you for being here, even remotely.
Thank you so much.
Okay, next up we have, I'm just checking the screen. We have Stephanie. I don't see Stephanie. Rob Schacht. Rob, you can unmute yourself. You're up next.
Thank you, Madam Chair. Thank you, Madam Chair and members of the committee. Thank you for the opportunity to testify in support with modification of House Bill 5859, an act concerning employment of individuals in agricultural labor. My name is Rob Schacht. I own and operate Huntsbrook Farm in Quaker Hill, Connecticut. This bill is meant to address the $20,000 per quarter threshold that requires an ag employer to register and pay into the unemployment pool. This bill raises that threshold to $25,000. I would like to say that in 2008, when I hired my first agricultural employee, minimum wage was at $7.65 an hour, and this $20,000 threshold was in place at that time. I'm not sure when the $20,000 threshold was first put into place, but it's been at least 15 years since it's been looked at. As minimum wage has increased, last year I paid all of my employees on my farm $15 an hour, and I crossed that $20,000 threshold for the first time with 3 full-time employees. So what I would like to ask the committee to consider is raising that threshold proportionally to increase it with the proportional increase in minimum wage that has taken place. Like the committee to consider that many small farms are seasonal in nature and might only cross that threshold in 1 quarter of the season when the workload is at its greatest for a small farm. And then the third thing is to consider a mechanism to allow farms like myself who just crossed that threshold for the first time in 1 quarter to unregister and fall back under the new threshold. So that is pretty much the issue in a nutshell. And if anybody has any questions, I'd be glad to answer them.
Thank you. Representative Ackert.
Thank you, Madam Chair, and Rob, thank you for your testimony. And you just made a great point, thinking about when the legislation was put in, and we're at essentially double the pay that when you mentioned the first $7.65 an hour, I think you said was $7.65 for unemployment. Minimum wage at the time. What is the time frame that you actually hire your workers? Is it a one block in a month? How does that work in terms of the individual? Do you keep them on full time, or is it obviously harvesting time or planting time? I don't even know what you do, by the way. What kind of farm is it?
So sorry, I should have clarified that. So I'm a small diversified vegetable operation. My labor season runs from April through the end of October. Pretty typically, my labor requirements are that I bring in 3 full-time people. In April, I add to my labor pool with maybe a full-time for a month or 2, but mostly part-time individuals in the summer season when markets and harvesting and planting and everything is happening at the same time. I mean, if you think about the months of July and August on a small farm, if you took and made a list of every single thing we have to do on the farm throughout the season, everything on those lists has to be done in July and August. So the labor requirements increase dramatically just during those 2 months. And then typically, as September comes, a lot of my part-timers are people who are either obliged to go back to school or go back to work in September. I have a lot of teachers that actually work for me in the summertime sometimes. I go back to my 3 employees for the last couple of months of the season, and we usually end our season at the end of October.
And do you know of other farmers? I know I meet with the farmers. I'm involved with 2 my district covers 2 agriculture areas, Tolland and now the Southeast agriculture area. And they bring this up, but without really giving us some of the hard facts. So I think it would be great if the, Connecticut Farm Bureau or somebody kind of really chimed in. Maybe they are. I haven't seen them in this, in our list here, but reach out to them and see how many farms are actually affected by this. Because I know that Representative McCarty's got one in her district that we really reached out to her. And Doug Dubitsky up in the north end has multiple farms that have reached out on this issue. So looking forward to getting more information on this and seeing what the right number would be if we do take an opportunity to move this. So thank you for your testimony. Thank you again, Madam Chair.
Thank you.
Thank you. And I just have one question for members of the committee. So with having hit that threshold, you said last year, were any of those employees then eligible for unemployment last year? And did they receive unemployment?
No, this wasn't about any of my employees filing for unemployment. This was simply that once you hit that threshold, you have to register with the Department of Labor and file an unemployment return every quarter moving forward, whether you hit the threshold in any given quarter or not. Once you cross the threshold once, you are forever burdened by having to make those filings and pay a percentage of whatever wages you're paying out into the unemployment pool.
I understand that, but my question really goes to the heart of the matter, because unemployment and these, burdensome forms that you have to file really are there to protect individuals who then would qualify for unemployment. So as I understand it, if we raise the threshold, then people who would qualify now today at the $20,000 quarterly level would no longer qualify unless that employer got to the $25,000 level. I think I'm
So-
understanding correctly.
So what I could say to that is I've been now employing people since 2008. When I hire people, they come into my operation understanding that it is a seasonal position and that it has both a start date and an end date. And I've never had an employee file for unemployment insurance when the season comes to an end. So I don't know if legally they would qualify to be able to do so. But I do know that most of the farms that I know that operate in this seasonal capacity do so with employees that understand that there is both a start date and an end date to their employment with the farm. I think that one of the things that the state has to take into consideration in all of this is that small farms like us are barely making it in the state. We make about enough money to run the farm and to support our families through the season, and we're just about out of money as the next season is starting to come in. So every little hit that we're taking is complicating how things go. And with inflation the way it's been, we're paying the increases for our supplies and the wage increases that we're paying by trying to pay our people a fair wage that they can actually try to live on. The ability for us to raise the price on the food that we grow and sell out into our communities is not there. People will stop eating locally grown fresh food if it ends up costing too much for them. And so while all these increases have taken place through the years, I have not been able to raise the prices on the food that I grow in probably the last 5 years without having a significant hit in the amount of food that I'm able to sell. So, it's a bigger picture story about how do we support small farms in a way that are going to be able to allow the small farms in the state to be able to stay in business and operate at a scale that makes them sustainable. I know that from your standpoint, you're here to protect the employees. And what I can tell you is that most of the employees that have come to work for me are not people who are just looking for a job. As a matter of fact, people who are just looking for a job don't make good agricultural employees doing the kind of farming that we do. People have to bring a sense of passion and a sense of importance to what it means to grow food for local communities at the scale that we do it at. And they usually do so at a financial burden to themselves. Last year, I had 3 employees that one of them came from a 30-year management position at BJ's. One of them graduated medical school and was a physician's assistant and basically learned that she didn't like the way that the financial part of our healthcare system worked, and so she left. And another woman was a nurse at a nursing home, ran wings at a nursing home for 20 years, and COVID put her over the edge. And they came to farm because they felt like what we were doing was important, and they were willing to do it at a lower wage than they could certainly go out in the world and work for. And I know right now with the labor market the way it is, I've heard from a lot of friends that farm that are talking about potentially having to scale back their operations and maybe not even continue their operation in the way that they have because they can't find employees who want to do this kind of work. So, you know, there's a bigger picture to it all, and I don't mean to expound on all of that because it kind of gets away from the main issue here, but back to your question, I've never had an employee file for unemployment insurance.
Thank you for your testimony here today. You are correct that we are responsible for making sure that we're protecting the interests of employees. That's our charge as a committee here. But just so you know, I grew up in a small farming community in the 1950s, and it was, I always appreciated small farmers. Unfortunately, most of those folks have been pushed out by agribusiness, and I wish there were more small farmers like you. So thank you for being here today, and thank you for testifying.
Thank you.
Next up, we have, let's see, let me make sure he's on. Is he in the room? Frank Panzarella. Frank, while you're getting ready to testify, let me just announce for everyone who may be watching online or is in the room, we have a number of people who we've skipped over because they haven't been present. If they do come in before we conclude the hearing, we will give them an opportunity to testify today. So if you missed your time, or if you know someone who missed their time, please let them know when they arrive, either online or in the room. We will hear their testimony as long as they get here before we conclude. So next up, we have Frank Panzarella. Please begin, sir.
Good morning to the chairs and to the members of the Labor and Public Employees Committee. My thanks to you for the opportunity to explain why I am in favor of SB number 151, an act establishing a full employment trust fund. As a resident in Connecticut in New Haven for over 40 years and a former president of a machinist local, IAM Local 1990, I have seen thousands of good paying union manufacturing jobs disappear in Connecticut. Corporate greed knows no bounds and has left us today with a sadly deficient workforce of skilled workers. Meanwhile, hardworking immigrants are knocking on our doors and often get treated very badly. It's time we redress this kind of corporate folly. Young working class kids in inner city neighborhoods like my own have to choose between the street and unskilled service work jobs that are equally abusive with inadequate pay and no benefits. Meanwhile, CEOs are making obscene salaries. Today, our Connecticut legislature has an opportunity to bend the curve of justice back towards a truer democracy that works for all. SB 151 is a modest reform that would give our state an opportunity to create thousands of jobs, build working class affordable housing, create training programs for skilled manufacturing workers, and hopefully also support new immigrants looking to fulfill their dreams of economic stability for their families. Among the jobs that could be created are green jobs, renewable energy, including manufacturing, installing, funding solar and wind power, mass transportation, including creating, manufacturing, operating sustainable vehicles, cars, buses, and trains, mass transit infrastructure in the form of bus routes, railways, and train stations across the state, waste management, coordinating and collecting recycling, care work training programs, child care training programs for child care providers, and elder care training programs to create more jobs for health aides and nursing home workers, and housing rehabilitation, green housing construction. Lastly, the true strength of our state comes from millions of tax-paying workers, unlike many wealthy CEOs and corporations who pay almost little or no taxes. Working people believe in carrying their load and contributing to the greater good. They are the backbone of a healthy economy. Such a program should be aimed at bringing an honest manufacturing sector back to Connecticut and encouraging corporations and the wealthy to pay their fair share by making it a stipulation of any program created under this act. And I just want to add, I was also a member and a board member of the West River Neighborhood Services Corporation in New Haven. And we are currently in the process of building 60 units along the Boulevard, MLK Boulevard connector. Thanks for your time. If I'll answer any questions you may have.
Thank you. I don't see any questions. I have a couple. You know, this is a proposed bill that we're hearing today, and so there aren't a lot of details involved.
Sure.
And I have talked to some advocates for this proposal who have explained that this in fact is something that is being launched in a number of states nationally to really begin to raise awareness about other ways we could approach employment. And so I appreciate you being here. I wondered if any of those other states, if the bill has actually, or this kind of proposed bill has moved forward in any of those states.
Not that I know of. I think it's just in the beginning phases of being brought up in many states. And, you know, I think one of the important for me is it's having a designated fund for creation of these kind of things, because very often there are so many competing interests in the calculations of legislatures that it's difficult to know if real things are going to happen when funds are going many, many different directions. And so to me, this is a way of saying we have a commitment to these areas, and we're going to create a fund that will actually be hopefully lockboxed into and not be pulled aside for other uses. And so that's the concept.
Well, I certainly appreciate you being here today, bringing it to us to consider. You know, it does harken back to days when there was, I mean, we're not suffering from high unemployment today, but we also have a lot of workers who are earning very little and are not fully employed or working in several jobs to become, you know, to make enough to pay the rent. So it does harken back to the days when we had WPA projects all over the country that, you know, have given us some of the most beautiful structures that we cherish today. So, you know, it's interesting to think about, and we really appreciate you bringing this forward today. Representative Ackert.
Thank you, Madam Chair, and thank you for being here, Frank, and bringing this support for this legislation. You know, you made me think of it because you thought about good paying jobs, because obviously you got trained in a good profession for yourself. And I look at, you know, Connecticut already has multiple, and I'm going to call them silos in a way, that because we don't really collaborate them all together. And that's, you know, training for manufacturing. We have the apprenticeship training program that we have for manufacturing. We have incentives to hire people to get into those jobs and take those. Your community yourself also has training programs for the youth to get out into the other, you know, good paying job trades and things like that. So what if we just don't see what we have for opportunity that way and collaborate them together, actually see what we are doing. And then, you know, I think maybe that's the missing link, is that we haven't tied them all together. Don't know if we need a fund to do it, but maybe just see what we are putting the funds into now. And then seeing how, if it's, you know, if we need to broaden that we broaden that, but we are investing. Connecticut's investing in a lot of good paying jobs. It's just, sometimes it doesn't get the level of us knowing what's going on already in the state. So I appreciate you tying it though together to housing and other opportunities to make it more of a collaboration outside just the workforce. So thank you.
Yeah, thank you. I think it would be a big difference if there was a structure in place that allowed to look at the bigger picture and sort of tie them together in a more cohesive way, and particularly the aspects of like affordable housing, because we have a serious affordable housing shortage. I know in New Haven, we have a really big problem with that. So thanks very much. Any other?
Thank you for your testimony today.
Thank you.
Next up, we have, just checking here to see, I don't see Jennifer Perez, so Dustin Nelson, you can unmute yourself. Thank you.
Thank you. Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, Vice Chairs and members of the committee. I am Dustin Nelson of Vernon, and I am testifying in favor of House Bill 5859. An act concerning employment of individuals in agricultural labor. I serve as the immediate past president for the Connecticut Nursery and Landscape Association, otherwise known as CNLA, a collaboration of over 300 businesses. The Connecticut green industry accounts for 51% of agricultural production in our state, with a total jobs impact of 43,000 and an economic impact of $4.7 billion. Through CNLA, I work with young professionals and we discuss topics such as hiring employees and all the additional responsibilities that come with it. We run partial budgets, pro forma cash flows, and other financial planning tools to help assess if it makes sense for them to hire an employee. For small businesses making your first hire, it is a big step and vastly changes your responsibilities as a business owner. The focus shifts from production within your company to managing people. Under the current law, hiring an employee has disadvantages, especially in a seasonal business such as agriculture. As one of the previous speakers had mentioned, a lot of our employees in this field are transient workers or people who are looking for a second job, maybe teachers or people who work other seasonal jobs. So this can, even if they're not filing for unemployment, this can fit in with their job scopes over the entire year. CNLA is committed to these employees by partnering with DOL and looking to bridge those connections between these different seasonal jobs to help reduce the burden on the unemployment system and ensure we are keeping people skillfully employed. The update to this existing statute will raise the threshold from $20,000 to $25,000 per quarter in wages, and is one way to help small businesses generate additional economic activity in Connecticut. Our state has made significant investments to attract innovation to our state, and this is one way that we can invest in something as fundamental as our food supply. We are making fresh, healthy food more accessible to the residents of our state through this bill. Thank you again for the hard work you dedicate to the residents of our state and working to help make Connecticut a great place to live and work. Please vote in favor of House Bill 580 or 5859 to encourage growth in small agricultural businesses.
Thank you. Any questions? Representative Ackert.
Thank you, Madam Chair, and Dustin, thank you for serving on that as president. Just quick, do you know how many, and I don't know if you said it in your testimony, I mentioned, how many of them of your association members fell into this category? Did you give that stat, or do you have that stat?
I don't have an exact number at this time, but I can get back to you with that.
I myself would preach, I'm not sure if the committee would, but I'm just curious if how many fell into that, and if there's and you can have, if they wanted to provide numbers that, they got to the $50,000 threshold on a short duration of workforce. So those numbers would be would make it shed light on what's actually happening regarding this. So thank you again, Dustin, and thank you, Madam Chair.
Thank you. And if you get that information to our committee clerk, Cameron Clark, he will get that out to the members of the committee. So thank you very much.
Thank you.
Next on the list, we have Russell Garudi. If Russell is here, I don't see him. John Catalan, who is here in person. And I know I mispronounced your name, Catalan.
Close enough, Senator.
Well, I know we've met before online.
Yes. It's actually, my dad's from Northern Italy, so it's really supposed to be Catalan, but anyway. Senator Kushner, Representative Ackert, members of the Labor and Public Employees Committee, thank you for the opportunity to testify on House Bill 6462
and that concerning the recoupment of state cost attributable to low-wage employers. My name is John Catalin. I'm with the Connecticut Alliance of YMCA's. Our YMCA's in Connecticut are concerned about House Bill 6462. When this legislation has been introduced during past legislative sessions, it always contained a nonprofit exemption. I would share with the members of this committee that most of our Y staff members enrolled in Medicaid are currently childcare workers. Our state pays our childcare workers so poorly, they're eligible for Medicaid. You know, what we do appreciate the investments the state of Connecticut has made in the child care industry during the past 2 years, but it's still inadequate. And we're unable to increase parent fees to increase staff salaries because many of these children are enrolled in school readiness or care for kids. Our YMCA's do offer health insurance to these employees, but they have found that being enrolled in Medicaid is a more affordable healthcare option. I would also add that any additional fees we are required to pay as a result, you know, it would result in a decrease in financial assistance for our childcare programs, summer camp, swimming lessons, athletic programs, membership, and the list goes on. I respectfully request this legislation be amended to provide a nonprofit exemption. Thank you, and I would be happy to take any questions.
Do you have a question? Representative Acker.
Thank you, Madam Chair. And I'm looking at the legislation. So it's your thoughts, John, that franchisors would also, you'd fit under that terminology?
It's a matter of interpretation, I would guess, just, you know, to be on the safe side. So our Ys are in all, we have 21 Ys in Connecticut. They are all independent. And so we have 4 of those 21 Ys that have over 500 employees. So that's, you know, we're concerned about it.
Yeah, without it being specific, because I was trying to figure, and it does work on, it says franchisees. So any large franchisor, if you fall under that, independently owned would be the franchisees.
Right.
Thank you. Thank you. So I think we'll have some dialogue on this. And I'm glad you bring up the point about your reimbursement rates for, you know, our childcare workers. I've been working on care for kids since I think I got into the legislature over a decade ago. So
No,
we'll keep working on it.
Yeah, you've always been supportive. I mean, right now, we're paying our childcare workers $2 to $3 more than minimum wage. It's the only way we can attract childcare workers right now. And we still have statewide in Connecticut, we're the largest nonprofit provider of childcare. We have 120 childcare job openings in the state, which has resulted in 20 classrooms being closed.
We have a problem with workers, finding workers in the state
Right.
overall, and if we don't pay them enough, we're not going
Right.
to get them. But John, thank you so much. I appreciate it. And thank you again, Madam Chair.
So I do understand your point. I take it. I think that I'm guessing that the advocates who worked and the legislators who proposed this bill were not intending to impact nonprofits in our state. We appreciate the service you provide in our communities, and we're well aware of the issues about not reimbursing rates high enough to really adequately both cover the costs of your services as well as pay the workers enough to live on. So, you know, we've made improvements. We've
Right.
worked hard at that. Hopefully this year we'll make additional improvements. But I'm guessing without having talked to the proponents of the bill, but I'm fairly certain it was not intended to affect our nonprofits, because then you would be coming to us asking us for the money to pay the penalty, which we have created in the first place. So it doesn't really make a lot of sense. So, but in any case, thank you for being here today.
Well, thank you, Senator. And I've talked to a couple of the proponents of the bill, and that was not their intent. But obviously, I have to be on the safe side to make sure we're recorded on the record that we're concerned about this. But I thank you for your comments, Senator.
And it's always good to see you.
All right, thank you.
For coming. Next up, we have Philip Harvey, if he is here. Yes, he is. Number 21, Philip Harvey. We see you're there. You need to, if you can, turn on your camera and unmute yourself.
Hi, I thought, oh yeah, video.
Great, you can begin. We see you and we hear you.
Okay, good. My name is.
We saw you for a minute.
Yes, good morning. I'm sorry that I do not know your name, so that I will just have to say I feel privileged to be testifying this morning to the Committee on Labor and Public Employees. I'm here speaking in favor of Senate Bill 151. I am a professor of law and economics at Rutgers Law School. And for the past 40 years, my research specialization has been on the problem of unemployment, how to solve the problem, how to achieve true full employment, meaning good jobs for everyone who wants a job, and how to turn what is currently a burden, the support of a population of individuals who are kept idle, not because they want to be idle, but because there is not paid employment available for them, into a resource for the community. And I think that that is exactly what SB 151 is intended to do. I was the principal advisor to Representative John Conyers in the design and drafting of a federal bill that would provide in a much more specified way the benefits that SB 151 would. And I also have was advising Letitia James, who is now the Attorney General of New York, when she was public advocate in New York and was thinking of running for mayor instead of Attorney General. And she wanted to sponsor a full employment bill. And the organization with which I'm affiliated assisted her in drafting that bill. So, and it actually was submitted to Legislative Council, and then she decided to run for Attorney General. So we have bills both at the federal level and at the state level that provide models for this kind of legislation. What I'm going to do today, because the bill before you is at this point a proposed bill with very limited terms, I'm just going to address some of the things that are addressed in the bill that I think should be called to your attention for revision. First, the bill as it's described would allow public sector entities and not-for-profits to receive the grants for the job creation projects. I think that should be limited to 501c3 organizations, charitable ones. There are more than 20 categories of not-for-profit organization. And I think that after much thought on this subject and discussion over the years, it really is best to limit it to 501c3, the charitable organizations, because they are the ones who actually would be providing the kind of services that program is desirous of providing. Secondly, the on-the-job, the training requirement describes it as a training program. Most people think of training programs as freestanding. And yes, I think that the bill should support the funding of freestanding training programs. However, as was pointed out, there are a lot of training programs funded mainly through the federal government and the WIOA Act with local workforce development boards that are, statutorily directed at the private sector. I think
Harvey, your time has concluded. Please finish your remarks.
Okay. I have a list of things. I'm sorry I didn't submit a written testimony before today. I frankly didn't know how, but I will forward my remarks to you in case they will be of benefit if you decide to fill out the bill, because I think there are a number of things that you should be aware of based on thinking in this over the decades by people involved in this that should be included in it. Thank you very much.
Thank you very much for your testimony here today. And you are, we would certainly be eager to receive your written testimony, you can do so by sending it to our clerk, Cameron Clark. And if you have a piece of paper, I'll give you his email. It's
Yes, I'm writing this down as you speak.
okay. It's Cameron, CAMERON .Clark, CLARKE at CGA. That's the Connecticut, short for the Connecticut General Assembly, CGA.ct.gov. And
Okay.
I'd be happy to look at your testimony. We appreciate you being here. It's we had some previous testimony about the bill, and we understand this is an initiative that is being looked at around the country by different states, and also, as you mentioned, on the federal level. And I can tell you just personally, it's great to drop names when they're people I know personally and admire. So both Letitia James and John Conyers are people I've admired. So thanks for being here and thanks for testifying. Okay, next up, Brian. Let's see, I think Brian might be, hold on. I'm checking. There's so many places you have to check to see who's up next. Okay, so thank you for, it's great to have a number of eyes here that are helping me figure this all out. Brian is testifying in another committee at this moment, but will be here shortly. And so we will go back to Representative Rosario. It's great to see you here today.
Likewise, Madam Chairwoman, thank you, Chairwoman Kushner, Chairman Sanchez, ranking members. Thank you for your time. I'm here to support House Bill 5033, and that concerning the compensation of incarcerated individuals. I have submitted testimony for the committee. Oftentimes, you know, the state of Connecticut has been a champion for workers' rights, whether they be in factories or even in our tech sector. But we often forget about our incarcerated individuals who are providing a service for the state of Connecticut. It was alarming to me when I went to a conference this past winter to find out that Connecticut is one of the lowest paid wages for inmates in the country, if not in the Northeast. I want to help change that. The last time inmates in Connecticut received a pay raise was in 2002, and subsequently, I believe it was reduced by about 10%. Each and every one of us is driving a vehicle to and from the Capitol, and on our vehicles, we have a license plate. That's a service that was provided by a Connecticut correctional inmate. When the times are hard during the pandemic and the state had no place to go for masks and hand sanitizer, those jobs were done by our Connecticut inmates. A lot of those folks, they're doing skilled work. They're in our kitchens. They're doing all types of jobs, helping out the DOT. And basically, all we want to do is get the state of Connecticut in line with all the other states in New England, so that our inmates could get a better wage for the work that they're doing. And oftentimes, these inmates, they rely on family for money for commissary, and a lot of these folks are on fixed incomes. They may have a grandmother or a mom who's on a fixed income, and that $50 that they're sending to their son or daughter in a correctional institution, that could hurt their bottom line. And it's the difference of paying for medication or bus fare. Or I know we're doing free bus transportation now, but some other service. So thank you for your time, and I'm open to any questions.
Thank you. And I do want to just first thank you for bringing this proposed bill to our committee, because I know myself, and I think many of us on this committee were really totally unaware of the wages that are earned by folks who are incarcerated. And we're aware of some of the services. I'm glad you pointed out the license plates on our vehicles, but other services that are provided by incarcerated persons. And I think that the lack of awareness as to the amount of pay that is earned is kind of shocking. And so I appreciate that you brought it forward. I know there are a few people here who have questions or comments, so let me call on Representative Ackert.
Thank you, Representative Rosario. Appreciate your testimony, and you presented this to us. Two things, if you could, is if you know, because I didn't looked up, there's no testimony posted by you, but if you could let us know what the surrounding states are doing, that would be, to me, it would be very, very helpful. And secondly, I know in the past, I work a local agricultural fair and have for many years, and the value of those that were incarcerated that come out and help the fair is immeasurable. They would not even be able to pull the fair off if they didn't have these hardworking individuals come out and help. And they love getting out, to be quite honest with you, getting out and working and putting up fence posts and just just socializing with others. It's just such an advantage to them. In the past, the Connecticut did not charge the fair, but now they charge the fair a sizable fee to have them on site. And you would think that that dollar, I'm not sure if it does, would also go to help the cost of supporting the inmates on a wage. So that to me is would be, if you know what the others are doing, but also what the state is, maybe I can look into that, maybe check what the state is doing with the funds. Maybe it's to pay transportation or something, but it was quite a sizable fee that the state charges these fares and that they didn't charge in the past. So thank you for your testimony, and would look forward to seeing what other states are doing, so we can be at least comparable. Thank you. Thank you.
Thank you, Representative. Just to give you an example, and I'll get you the data. I've actually been working with OPM on this issue. There could be a cook who is cooking for thousands of inmates, making $1.75 a day, where in Massachusetts they could be making $5 a day. Those are just examples. And also during the wildfires out west, this issue became highlighted because during those wildfires, it was inmates that were putting out the fires. They were relieving the brave firefighters putting out the fires, and they were getting paid $8 a day. And there were about 50 inmates that passed away during those wildfires. So Governor Newsom actually stepped up and has been one of the leaders in this charge. So I want to thank him for that. But definitely, I would love to get you that information.
And just to follow up, so the money that they earn, it's theirs when they are released. Is that correct? Is that something that they can keep, or is this because it's their income, right?
Correct. And I know some states, I've been using Massachusetts as a guide. It actually goes into sort of like an inmate trust fund. So if they have a certain amount of money that they can use for commissary and whatever toiletry needs, and upon release, they'll get a check with whatever amount of money that they accumulated.
Thank you again, Representative, for your advocacy, and thank you, Madam Chair.
Thank you.
Thank you. And I do believe, we can work with you and OPM, but also OLR to make sure that we have all the information about the surrounding states as well as what's going on in the country. So thank you for that. And I know Representative Wilson has a question.
Thank you again, Representative Rosario, for being here and bringing this issue up. The small question that I have is this proposal also, I believe, would probably help in some of the areas for inmates who get out and have a larger restitution. A lot of times they have to pay back. So an issue like this could possibly help in some of those areas. Am I right or wrong?
Absolutely. It could relieve potential child support payments. If they have any arrearages or any other needs when they get released. Oftentimes, you're relying on friends and family to help get you back on your feet. And what better way to help yourself get back on your feet with the hard work that you're doing. These inmates, they're skilled folks. But when I was in code enforcement in the city of Bridgeport about 10, 15 years ago, and we used inmates from the North End Correctional Facility to board up our abandoned houses and clean up our lots. And some of the most skilled people were the inmates that we got from North Avenue. And oftentimes when they got released, we ended up hiring them in our public works departments because they were so good. So this is definitely a good opportunity to give you some motivation to get out and to pursue other opportunities.
Thank you again.
Thank you again for your testimony. It was extremely helpful, and I'm very thankful for the legislators and all of the advocates who worked so hard in this legislative office building and at the Capitol to bring awareness as to how the state of Connecticut is treating people who are incarcerated. And many people would not be aware of this, would not be familiar with it, have not got the lived experience that has been brought to us. And it's making a big impact. So thank you for what you're doing.
Thank you, Madam Chair.
Next, we're going to go to on Zoom, we're going to go to Jennifer Perez.
Good morning.
Good morning.
Good morning, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, and members of the Labor and Public Employees Committee. My name is Jennifer Perez, and I'm a lifelong resident of Bridgeport. Currently, I'm in graduate school at Southern Connecticut State University, working on my social work degree. I'm here to urge you to support Senate Bill 151, an act establishing a full employment trust fund. This bill aims to create employment opportunities and training programs that would lower unemployment and underemployment rates in Connecticut. Currently, Connecticut's official unemployment rate is under 4%. However, when you factor in those underemployed in part-time work, that number nearly doubles or more than doubles. Job creation and job training programs are essential to growing the economy, especially if we're on the brink of recession. With this bill, we can create job training programs for high demand industries such as childcare and elder care and reduce the rates of underemployment. Growing up in Bridgeport, there's a rich history in factory work and in the early 20th century and workforce housing. And unfortunately, in the middle century, we know that there was a major decline in that area, which led to a lot of the issues that Bridgeport faces today. And so the lack of sustainable jobs that Bridgeport has kind of leaves our residents here one step behind others. So increased employment opportunities in the state can lead to residents being able to afford to live here. It's important that there are opportunities for all workers in the state to be able to make a living and help our communities thrive. So this bill has the potential to create these new jobs and infrastructure for the state. This type of legislation can help reduce costs related to the problems that result from lack of jobs and good wages. So I urge you to support Senate Bill 151. Thank you.
Thank you. And thank you for your advocacy. I have been getting your emails and I've been responding to them. And I was glad that you made it here to testify today. So we've had quite a bit of testimony on the issue today, and I think we're much more aware of what you're proposing here and what you're advocating for. So thank you for making sure that you're involved in the community. So we appreciate it.
Thank you.
I don't see any hands at this time, so we will move to, I believe, next on the list, and I'm guessing that that's Brian that just came in. I'm sorry, is it Mezek? Marshall Mezek.
Yeah, I apologize for my tardiness. I just testified in housing.
We
At the
heard-
same time, the stars aligned. Okay, good morning, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, and members of the Labor and Public Employees Committee. My name is Brian Mezek. I'm a Connecticut State Marshal. I'm the president of AFSCME Local 2193, which organizes the Connecticut State Marshals. I'm here speaking in support of HB 5856, an act concerning state marshals' health benefits. We put in written testimony also, but I'm just here this morning to communicate that state marshals are sworn public officials with the status of peace officer. We serve court documents and legal process all around the state, and we're a really important part of the state's judicial system. We serve the public in every corner, town, and city of Connecticut. Our state marshals are currently given the option of obtaining state employee health insurance through the comptroller, but we must pay the full cost of the premiums. And unfortunately, this fact has held back the state marshal system in both recruitment and in diversity. Our job is dangerous. It's a time-consuming job, requires us to work early mornings, late evenings, and quite frankly, work all the time. Marshals have a unique function in our state government. We're not state employees, but we're agents of the state, and we perform a function of the state government, namely service of process and enforcing orders of our state courts. It's a unique position. We're controlled by the state. We're not private individuals. We're appointed officers with the status of peace officer. But despite that important function we fulfill, there's no healthcare benefits provided. And this has made the job less and less attractive for applicants. There's about 175 of us who keep the court system moving by serving process and enforcing court orders. Only 24 of our marshals are women, and an even smaller amount are people of color. And unfortunately, these numbers have barely changed in the past 20 years. Often when asked to describe the job that marshals do for the state of Connecticut, and when I tell them, people find it almost unbelievable that we perform this function of the government, one that requires time, dedication, and risk of personal injury to ourselves, and we do it all without health insurance. The state marshals urge the Labor Committee to help rectify this problem and help plan and guide the future of the state marshal system in the years ahead. So we strongly encourage the committee to support this bill, and I thank you for your time, and I'm happy to answer any questions you might have.
I have a couple of questions. And thank you for being here. And again, as one of the things that we learn on these committees is that there's so much going on that we don't know anything about. And you bring it to our attention, and we are here to address issues and problems and try and fix them. I know that one of the most compelling, I mean, first of all, everyone should have healthcare. So just that's as a starting point. But I realize that that's not coming up in this committee. But aside from that, I think what concerns me is that we have a difficulty recruiting marshals, filling those positions. And you've spoken very well about the demographic issues that are also make it more difficult to recruit and address more equity and more diversity in who we hire. So I think that what will be important for this committee to understand is that because you're not state employees, we think, well, maybe you're not eligible to be in the state employee healthcare plan. Can you address that if you have information about that, especially if there are other people in your kind of situation where they're not state employees, but they are in the plan?
Right. Well, when I say our marshals are unique in state government, like I actually mean they're unique in state government. We have this function as peace officer. We enforce civil arrest for the courts. We enforce all the court judgments. We serve all the restraining orders around the state. We are unique. The only other analogy I think we could make are the probate court employees, who are, from my understanding, are technically not state employees. That system is in large part funded by the probate fees. So if you take that kind of analogy and apply it to the marshals, our system is sort of funded by fees that are set by the legislature. Like we're not true independent contractors. We're compensated as independent contractors by fees that are set by this building. So I think the analogy might be the probate court system, and the state does provide those employees of the probate court system state employee healthcare.
That was exactly the group I was thinking of, because we've had testimony from probate court employees.
There's another one I'd love to know.
But I was thinking about those employees. So it is doable for us to put state marshals into the health plan, even though you are not technically state employees. That was really what I was getting at. So thank you for that. Representative Ackert.
Thank you, Brian. It looks like you got a bunch of colleagues here too today. So can you describe because fortunately, I haven't had a marshal come to my home, so I'm happy that is not. And then my goal is to not have that happen in my life. So unless it's something good that they're going to bring me. So what is the role? So explain at the day of a state marshal. It's like a full-time or full-time plus or part-time? Can you tell me a little bit about your job?
I would love to work part-time. I don't think that's possible. For all of our state marshals, they're working all day, every day, serving process. Basically, every case that's commenced in our state courts, from family cases, custody cases, modifications, civil cases, evictions, foreclosures, divorce matters, all those cases are commenced by service of process. So the service of process function in Connecticut, that governmental function, is given to state marshals who are appointed. And we also enforce court orders like evictions, seizure of property, enforcement of money court judgments. And we also enforce the civil court arrests for the court, contempt of court, what's called a capias warrant. So our day is all over our county. We're appointed in the 8 counties of Connecticut. So a lot of driving. And we're also required to report to the courthouse to meet and consult and receive paperwork from domestic violence victims, those who are applying for restraining orders and civil protective orders. And those ones, we hit the ground running. So we have a system where every day in 13 courthouses around the state marshals are mandated to be there at 12:30 and at 4:30 to meet those persons and receive the process. We don't get compensated for that. We get compensated on a fee for service basis.
Can you explain that a little bit? So if you're requested to, and you're not going to do too many happy things from what you just list there, so, so when you go into whatever it may be, a case, child issue or something like that, are you paid a fee structure for that type of work? Is that how it is?
Right. Our fees are set in statute, and it's sort of a 4-part formula: fee for service, fee for pages, fee for travel. But that's set in the law. We can't deviate from that. So there's uniformity in that, and we're controlled by the state in that regard. When it comes to restraining orders, civil protective orders, and all the other kind of process for indigent persons from the court, the judicial branch pays us. So we're being paid directly from the state treasury on those things. And it's a lot of work. It's a very large volume of work in that category.
And so essentially where you're paid from is for state services, to be quite honest, right?
That's a massive component of how we're compensated.
Okay. Thank you very much. Thank you for being here. Thank you, Mr. Chair.
Thank you. I have one small question.
Sure.
So you said right now you guys have 175.
Mhm.
Is that, or you have open positions, I'm guessing, as well?
Yeah, well, my colleagues are going to be testifying to some of the recruitment, so I don't want to repeat the testimony, but
I'll wait on.
we had trouble recruiting last time, and you're going to hear more about that in the testimony coming up.
Excellent.
Yes.
Thank you so much, sir.
You're
Any
welcome.
other questions? Thank you.
Thanks.
We're gonna move on to Shirley Reyes. Shirley Reyes is not here. So we're gonna have up next Senator Marks.
I've never sat here before. I'm Senator Marks from the 20th District. Hello, Senator Kushner and all of the other distinguished members of the Labor Committee. My name is Senator Marks, and I'm here to testify on Senate Bill 489, which is a bill that I introduced. It is a bill limiting the number of days that an employer can mandate an employee to work. A little history of this bill. I am a nurse. I've been president of my local VNA of South AFT, VNA of Southeastern Connecticut, Local 5119 for probably almost 20 years now. I've lost count. I'm not president anymore. And we were working, I've heard that you couldn't work more than 6 days in a row. Everybody would say that to me when I was saying we were being made to work 12 days in a row. So I looked up the statutes. This is before I was political. Well, I've always been political, but it's before I was political. And I copied that, put it on my desk, and it's been on my desk for 10 years. We were being mandated to work more than 6 days in a row in a work week. So that is what the statute states right now, that you can't make an employee work more than 6 days in a row in a work week. So before Yale took us over, we worked Saturday to Friday. So we would work the weekend, and then we would have to work Monday through Friday. So we were working 7 days in a row. So when I gave this to management, they didn't know that they were not doing what they were, obeying the labor laws. And so they would give us a day off during the week. Then when Yale came in, they changed our work week from Sunday to Saturday. So now we work Monday through Saturday. We can't get a day off because we're so short-staffed in nursing. And then they'll plug us in on the Sunday and we have to work the Sunday through the Friday. They're not breaking the law because it's 6 days in this week and 6 days in this week. Put together, it's 12 days. So I just can't think that that is why this legislation was passed when it was passed. I didn't ask the LOC. And I just find it's a very simple fix. I did read all of those opposed to this bill. Reading their testimony, I question whether or not they are currently obeying the law, because it was broadcasters, it was people talking about healthcare, and with all due respect, we all know about the shortage. If you really want nurses to work, don't make them work 12 days in a row. We're asking for 1 day off so we can go grocery shopping, so we can do whatever we want to do. If we want to sit, it's nobody's business what we do, but just give us 1 day off. So I really don't, I read all of the testimony against, and I would love to ask every single person that did write that testimony whether or not they realize that right now they cannot mandate their employees to work more than 6 days in a work week. So I find it simple, but yet I'm a freshman senator, which I think this all should be very simple, because to me it's common sense. I am learning that that is not always the case. I have not put in written testimony. I will this evening when I have a chance. I'd be happy to take any questions.
Thank you. Thank you for your testimony. Representative Acker.
Thank you, and thank you for serving all those individuals as a nurse. My sister is a nurse, and she finally went per diem because she just couldn't take the mandates from the hospital, unfortunately. So now this does not preclude somebody that wants to work, somebody that's in, that has a regular job, but bartends or is a wait staff. In no way does it stop somebody from getting scheduled on a part-time basis and wants to work, or the companies. No, I want to be there. I want to do that. As I actually have technicians that, hey, do you mind if I pick up some extra hours on the weekend? And my pocketbook cringes a little bit, but I need to get the work done. So, but in no way does that occur. Is that correct?
Thank you for asking that. That is so important. A few people have called me. No, it does not. When Yale changed the work week from Sunday to Saturday, we all sat in our desks and looked at each other, and they're like, do they know we get an extra $15 an hour on Saturday? So now if we've worked 40 hours Monday through Friday, we're going to get our hourly pay $15 an hour and then time and a half. So I can tell you right now, my children are gone. My life is much simpler. I volunteer to work 12 days in a row all the time because I've put 4 kids through college. So no, you can work 20 days in a row if you want to. You just cannot be mandated to. So that's what the law states. It's when I was a nurse, just a good old nurse being a good local president, and we had to post it all throughout the VNA's building, and they had to change the way they scheduled us because they were doing it wrong. So nope, you can, if you want to work, you can work.
Thank you. And so was it brought to Yale's attention that, hey, wait a minute, 12 days is, unhealthy as far as I'm concerned.
Yeah.
In the business that you're in, I think 4 days is
So
for you
yeah,
guys, but-
no, they do know that. We also have mandatory overtime, which we actually negotiated a really good policy with that, in that it's instead of, you're driving home and they call you up and say, hey, you have to go to Salem, so-and-so's catheter came out or their wound vac came off, it doesn't matter that you have something to do at 4 o'clock. That's how it used to happen. You would just, sorry, you have to go see this client. And you can't say no. So now we sign up for what days were available for mandatory overtime. So every week we need to sign up for 1 day. And you might not be called, but at least it gives the nurses some control over their life, and it's worked out pretty well. And we get paid $50 just to sign up. So there's some weeks I sign up for every single day. I know how to make all the money in 1 week. I'm really good at it. So when we did tell Yale this, we are actually still required to work the mandatory overtime, even when we're scheduled 6 days in a row. So we're already mandatory overtime for 6 days. Plus, then we still have to sign up for 1 day of mandatory overtime. When they say, you know, they plug you in on that Sunday, so then you're on for the next 6. Sometimes you can get a day off during that next week. But often you can't, especially in the summer, because there's too many nurses off. So our management at VNA, they said, you know, we'll do our best to try to give you a day off. We get told to put your name on the waiting list. That means if census is low, which in 40 years of nursing, I am not kidding you, census has been low 2 days that we have got to go home. So we have discussed it with them, and they have to fill their schedules.
And thank you, Senator. Any other sectors out there that you can think of? I mean, I've seen a lot of, you know, obviously the oppositions and the supports. Home health aid, I see, was another one that was supporting this legislation. Other sectors out there that you think that you maybe have reached out to you about your legislation?
No, I'm here fighting for my nurses and home health aides. That was Christine Moretti, home health aide, the secretary of our union. And you know what? It took us 4 years. We told them that we don't need home health aides on the weekends. Really, we don't give Medicare doesn't pay for home health aides like they used to. And we would argue and argue that our home health aides really do not have to work weekends. And they finally listened to us, and our home health aides don't have to now, and they're so much happier. I don't know of any other sector. I mean, the people that all opposed this were all in management. And I will say this till I'm blue in the face. I'll say it at every, wherever I ask questions. If you are balancing, if your business plan is on the backs of those doing the work in the field and doing the hard work, like the broadcasters that are out there in the pouring rain, you know, videotaping. If your business model, your business plan is based on earnings on the backs of the hardest working people, then my advice to you is change your business plan. So.
Thank you. Thank you for your testimony. Thank you, Madam Chair.
Yeah.
I have to run to another committee.
Thank you. And I don't see any other questions, but appreciate you being here and advocating on this important issue. So thanks so much.
Thank you.
Next up, it looks like we have Mary Claire Whelan.
Hi, everyone. Good morning, members of the Labor Committee. Can you hear me all right?
Great. Go ahead. We can hear you.
Great. My name is Mary Claire Whelan, and I'm the coordinator of the New Connecticut Farmer Alliance. We're a network of over 550 farmers from all across the state. I'm also a farmer myself at Massaro Community Farm in Woodbridge, and I'm a resident of New Haven. I'm here to testify on behalf of the New CT Farmer Alliance in support of House Bill 5859, an act concerning employment of individuals in agricultural labor. I submitted written testimony, and my fellow farmer Rob did a great job outlining the problem, so I'm just going to add a little bit of perspective based on my experience working closely with new and beginning farmers across the state for the past few years. House Bill 5859 updates the outdated payroll threshold that determines when farms are required to pay unemployment insurance tax. As Rob said, this update is long overdue. I think our colleagues at the Farm Bureau testified that the last time this legislation was updated, minimum wage in Connecticut was $2.66 an hour. As you probably already know, farming can be a really tough business. New and beginning farmers are often operating on razor-thin margins, and many of the secondary benefits that our work, like climate change mitigation and ecosystem benefits, are uncompensated, despite providing valuable public services. The financial challenges for small farms are more pressing now than ever, given the high cost of inputs and the fact that farmland prices skyrocketed during COVID. We really should be doing all we can to support the success of new and beginning farmers and avoid burdening them with additional taxes, especially when their payroll goes over the threshold only 1 or 2 quarters of the year. I want to tell you all a little bit about what it means for small farms to hire crew members for the first time. For a farmer in their first few years of production, it can be a big and financially precarious step to hire crew members for the summer. The transition from being entirely owner-operated to having workers is fraught with risks, but it's a critical step for farms that want to grow their businesses. It's also a really important step for farmers who are trying to look after their own mental health and avoid the trap, which is all too common in our industry, of trying to do everything yourself. Furthermore, we at the New CT Farmer Alliance don't want to disincentivize farm owners from raising wages for their hardworking crew members due to the fear of going over the unemployment insurance tax threshold. I myself have worked on farms owned by other people for the past 8 years, so I know firsthand that there are plenty of factors influencing farmers to keep wages low. But in our community, there are some really important conversations happening and growing awareness of how important it is to pay farm workers a living wage. Let's support farm owners who are already financially squeezed in a million ways in working to raise wages above minimum wage, not to keep them low. I totally agree with the point that you made earlier, Chairman Kushner, that unemployment is a critical support for individuals who work in the agricultural industry. In fact, the Alliance enthusiastically believes that farm workers deserve more protections than they currently have access to. But the farms we're talking about that would be affected by this change in legislation aren't big ag businesses with dozens of employees. We're talking about small farms just trying to get off the ground with 2 or 3 seasonal workers. We're talking about farmers who are sometimes paying themselves less than minimum wage in order to be able to hire help on their farms. I did the math, and if farms pay only minimum wage, they would reach the $20,000 threshold by having only 2 full-time and 1 part-time employee during their busiest quarter of the year. On a diversified small veggie farm that relies mostly on non-mechanized labor, which describes many of the farms that are part of our organization, I would roughly calculate that that's not even enough employees to manage the planting, weeding, irrigation, and harvesting of 5 acres.
Ms. Whelan, your time is almost up. Please conclude your remarks.
I would just add that in addition to raising the threshold to 25,000, we would love it to see raised to 30,000. We also think that the threshold should consider the average wages that farms are paying over the whole year and not just look at 1 quarter, and that for farms who have already passed the $20,000 threshold but are under the new threshold, there should be some recourse to stop paying the tax. Thank you for considering this bill, and we appreciate your support of Connecticut's next generation of farmers.
Thank you, and it's great to see the next generation of farmers right here, or in this case, on YouTube, on Zoom, but it's great to see you here and testifying. You did make mention of a couple of changes that you'd like to see that are not in the bill, and I don't know if you have submitted written testimony that would include those. Great.
Yep.
Okay, we will take a look at those as well. So thank you very much. I don't see any questions at this time. This is what always happens when you're like the 3rd or 4th person testifying on an issue. The questions have been asked, but thank you for being here today. Great. So next up, we have, let me just make sure that number 23 isn't in the room. I don't see her. So we will go to John Brady, number 25.
Thank you, Senator. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Ackert, and members of the committee. My name is John Brady. I'm a registered nurse, and I'm the Vice President of AFT Connecticut, a union of 30,000 members in healthcare, education, and public service. Senator Marks, just a couple of speakers ago, did a good job explaining a lot of what I want to speak to you about. I've come here today to testify in support of SB 489, an act limiting the number of days an employer can mandate an employee to work. Current Connecticut statute limits the number of days in a week that you can be mandated to work to 6. I believe that the intent of that was to have rested employees. However, there is a unintended loophole in the law, and that is that you can be mandated to work 6 days the end of 1 week and 6 days the beginning of the next, which makes a 12-day stretch. The use of this loophole has become a problem for some of our visiting nurses and our home health aides. Schedules of 12 days in a row, including days that often do not end at time, as Senator Marks had said, create unsafe situation for both our members and for their patients. A healthcare professional who's not rested is unable to give the level of care that they are trained to provide and that they have dedicated their lives to. And one of the side effects of this is that it drives people out of the profession, a profession that's already shorthanded. Also importantly, and Representative Eckert got into this conversation with Senator, is that this bill would not limit any employees who voluntarily want to work more than 6 days in a row. Something that most healthcare professionals would do in an emergency, or if they're just feeling rested enough to do it. So I want to thank you for considering my testimony, and thank you for the service of the people of Connecticut.
Thank you very much for your testimony here today. I don't see any hands or questions, but thank you for adding to the testimony of Senator Marks. So next up, Lisa Stevenson. Good afternoon.
Good
Now afternoon.
Good afternoon, State Senator Kushner, Representative Sanchez, and the members of the Labor Committee. My name is Lisa Stevenson. I'm a Connecticut State Marshal, and for 22 years, I've sat on the State Marshal Commission as an ex officio member. I'm here to speak in support of HB 5856, an act concerning state marshal health benefits. I have put in written testimony, but I wanted to share a few of my personal items today with the committee. In 1995, I was appointed and broke the glass ceiling in Hartford County as one of the first women to break into the job. Since that time, I've been heavily involved in the marshal system and have sought to improve it. State marshals are appointed officials. We're sworn officers for the state of Connecticut. We are directed by the state to carry out service of civil process, enforce court orders, and among many of the things that we do as marshals, and one of the most important factors that we do is the service of restraining orders and protective orders, children custody matters, and we execute habeas warrant arrests. Since the inception of the state marshal system, I was hopeful that the demographics of our state marshals would change. The goal was to see women, people of color, bilingual, younger people, younger marshals that would take charge. Our marshals need to be more reflective of our communities, and that has not happened. When the state marshal exam was first given by the commission, there was about 1,000 people that applied. The most recent exam in 2022 had 144 people. We are losing qualified candidates because we don't offer affordable health insurance. Yes, we can purchase the plan that the employees receive. Personally, I pay through the comptroller. My premiums are $900 a month. Marshals with families must pay $2,000 or more for a family. This fact is repelling good people to take these jobs on as a career. The state marshal system was created with hopes of a broader spectrum of qualified individuals that would serve the state in these jobs. But currently, we can only attract individuals who have insurance through another source. The opportunity to access these important jobs, these jobs that impact every corner of the state, have been closed to women and minorities. Asking people to do a dangerous job for the state without health insurance is not working. We lost several very qualified candidates this last exam because they found out we have no access to affordable insurance. The demographics of the state marshal will never change without access to affordable insurance. I'm among the few women to break into this position. I have worked diligently to help women and minorities follow my path, only to be disappointed that the barrier still exists. As a female marshal, one who seeks to improve the system, I asked the Labor Committee to support HB 5856. I believe the change will diversify the state marshals, strengthen the system for the future. I want to thank you for your time, and I'm happy to answer any questions you have.
Thank you for your testimony, Representative Wilson.
Thank you again for that testimony and for being here. Going back, and I know you talked about the examination and just the large contrast in the number of individuals interested in taking the examination. And I'm guessing when you're talking family planning and things of that sort, it's a deterrent for women to want to get into the profession, knowing its dangers and not having that health insurance support.
That's correct.
And the premium amount, I think you said 900 and then 2,000. Now, is everybody eligible for those opportunities? Could you explain a little bit more for us on that part?
The comptroller's office offers us the same program that the state employees have, but we have to cover all costs on it. So we're allowed that opportunity to have the best insurance, possible, but we have to pay the entire premium out of pocket every month. My policy does not have dental or health. And a lot of the family policies don't have that either because the premium is so high.
So essentially this not only would help individuals in that aspect of a lower premium cost, but something that's more manageable for the longevity of wanting to stay in the profession.
Absolutely. Yeah, it's definitely been a huge deterrent, and we actually lost a very amazing female candidate this last time because she just said she would have been totally qualified. She met every expectation. And then she found out about the health insurance and withdrew the day before we did interviews, which was extremely discouraging to me. We only had 2 females, so I felt like we closed the door to minorities and females.
Thank you. And I know when you talked about the insurance premium piece, the other part you talked about is, really it's the hope then for a lot of individuals that either their spouse or someone else has a source of insurance, health insurance. And so how many, you may not have these figures, but how many of those individuals do you think a good portion of the individuals that are state marshals have significant others or others that have, or they have another source of insurance beyond just
We do. There's
the
about
opportunity?
60 of us that are working with the state now out of
Okay.
the group of our 170. We have some gentlemen that are over the age and have Medicare and Medicaid.
Uh-huh.
And then we have a small percentage of individuals that have a spouse that has insurance, or they've retired out of the Department of Corrections or Fire Department and they have their health insurance through that. And then there's those that have to purchase it at the high price.
Thank you again for your testimony.
You're welcome.
Thank you so much for being here today and for all that you do for Connecticut.
Thank you.
And by the way, it's really impressive to meet someone who broke a glass ceiling. We always like to see that.
Appreciate that.
Thank you. Next up, we have Arthur Quinn.
Good afternoon. Good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor Committee. My name is Arthur Quinn. I'm a state marshal, and I'm also chairman of the State Marshals Advisory Board. I'm here to speak in support of House Bill 5856, an act concerning state marshals' health benefits. I've also submitted written testimony, but wanted to share a personal story with the group. On October 6, 2009, I was executing a capias warrant for the courts. I was shot twice. This occurred in suspect proceeded to open the door and immediately opened fire upon myself and my partner. We were within 2 feet of him. The subject held his 8-year-old nephew in front of him while he unloaded all the ammunition in his gun, firing at myself and my partner. While my partner escaped physically unharmed, I was not as lucky. I was shot in both my right arm and left foot. 14 years later, I still have ongoing medical issues as a direct result of this incident. I've been told by my doctors the issues are expected to worsen as I age due to arthritis. These medical bills almost bankrupted my family, as I was unable to work for over 6 months while I was in recovery. Most people are shocked to hear that I was performing a dangerous and risky job in state health benefits. At the time of this incident, I had extremely high deductibles and substantial medical bills. My fellow marshals had to organize a fundraiser to help offset the cost of paying these medical bills because the system was not designated to take care of its state marshals. The bill before you was needed badly to fix this inequity. Marshals encounter dangerous people and situations on a daily basis. These risks are increasing daily. While we are mandated to appear in court, as State Marshal Mezek referenced before, for restraining orders on a daily basis, the potential for physical harm to be inflicted upon the serving officer by unhappy and disgruntled parties is increasing. Many of the orders of protection require us to inform these individuals they must immediately leave their home under a judge's order. That information is rarely received well from the party to be removed, which places us at risk for physical harm. The same applies for the evictions we conduct. These two are quickly becoming more and more dangerous by the day. Our recruitment efforts are suffering. We've steadily seen the number of state marshal applicants dwindle, as Lisa and Brian both referenced, from 1,000 plus 10 years ago to only 144 in our December 2021 recruitment. Job of state marshal is not a career people can reasonably take on without health benefits. Last class, which was the recruitment of 21 and appointments are in 22, there were 23 state marshals appointed, only 3 were women. We actually had one female applicant, which Lisa discussed before, that she couldn't take it on because it was a demanding job and she could not have lack of health insurance. Of the 23 state marshals appointed, none were people of color. We've got to do better. I firmly believe that the lack of health care to state marshals is impacting our diversity and our overall recruitment. No state marshal should have to go through what I did, and I urge the committee to make this overdue change regarding health care for the future of the state marshal system. Thanks for your time, and I ask for your support of House Bill 5856. I'm happy to answer any questions you might have.
Thank you, and thank you for sharing your story about, you know, the very specific nature of the job and how you were injured and, you know, permanently harmed and disabled, you know, suffered a disability from that you'll live with for the rest of your life. That this is a subject that we've taken up in this committee about other first responders that have really been in a situation where they've faced a permanent disability and the impact that makes on your life. So first, let me just say that we're really aware of how difficult that makes things for you. And I'm sorry to hear that you suffered in that way and will continue to suffer as you age. And I really do appreciate your service. It makes me think of something unrelated to this legislation, but I did want to ask if you are covered by workers' compensation.
We are not.
Wow.
We are not.
That seems like another bill that should be in our committee.
Yeah, that's a lengthy story that I investigated after the incident happened, but we are not, to answer that question. The short story is no.
We will definitely continue talking with you and your colleagues about this issue.
I appreciate that.
As for the issue of healthcare, let me ask if any of my colleagues have any questions. Representative Wilson.
Thank you again for being here. Kind of just to follow up, similar question that I asked the last individual. When you went through the incident in 2009, at that time, was there the partnership with the state comptroller's office for being a part of their plans?
I'm unsure. I believe that the cost at that point was much higher than being on a private pay plan. But unfortunately, the private pay plan came with the extreme deduction. I'm not sure when the ability for us to buy into the state plan.
Okay, so your incident, your situation in 2009, you were pretty much, you had your own private insurance.
Correct.
Okay, and so that definitely made things probably astronomically more expensive when it came to the coverage and all of the things that were necessary in order to get back to where you needed to be to get back on the job.
Absolutely.
All right. Thank you so much for that information.
Thank you.
I don't see any other hands, so thank you for your testimony here today.
Thank you.
And next up, we have Sharon Ullman.
Good afternoon. My name is Sharon Ullman, and I am a Tolland County State Marshal. I started my 37-year career in the system in 1986 as a special deputy sheriff, working for a per diem rate of $60 per day, transporting prisoners working in courtrooms and lockup without benefits or health insurance. In 1989, I became a deputy sheriff serving civil process, including restraining orders and executing capiases for the state of Connecticut, which are civil arrest warrants, again, responsible for my own health insurance. In 1994, I was appointed Chief Deputy Sheriff of Tolland County and remained in that position until 2000 when the sheriff system changed to the state marshal system. During that 6-year period, I was covered by the state health insurance. Sadly, my 6 years did not bring me to the 10 years of state service required at the time to receive health insurance for life after the age of 55. In 2000, I returned to serving civil process as a Connecticut State Marshal. Most assume that as state marshals, we are state employees with full benefits, which is not the case, despite the oftentimes dangerous work the state requires us to do. Since 2001, we have been mandated to report to the courthouses across the state twice per day at designated times to receive restraining orders to be served for the judicial department. There is not an assignment we take more seriously, as these applicants are victims of stalking, domestic violence, and abuse. Serving these can be a danger to all of us, as the respondents often possess weapons, have committed acts of violence before, and are oftentimes mentally unbalanced. We have countless stories of threatening situations we've encountered. You just heard the harrowing tale from my colleague and friend, Arthur Quinn, who was shot while arresting someone for the state on a capious warrant. We have faithfully served the state of Connecticut, many of us for decades. Marshals should not have to perform this function for the state without health care. I was fortunate enough for many of my years to be covered by my husband's insurance until his retirement this year. But single mothers, single women, and qualified candidates should not be precluded from pursuing a career as a state marshal because of lack of insurance. I have been one of the relatively few women to have a long career as a state marshal. Our statistics on women and minority state marshals are pathetic. Lack of health insurance is a huge reason for this. We have a large percentage of our marshals who are older and retiring. To ensure that we can get the best qualified as well as diverse candidates to continue to serve the state of Connecticut in our vital roles, we need to make this change, and the state must cover its marshals with state health insurance. I thank you for your time and consideration.
Thank you for being here today. We've had a number of your colleagues here, so a lot of questions have already been asked. But it is nice to see you all participating in this conversation and testifying here today. So we will definitely be interested in deliberating on this issue. So thanks for being here.
Thank you so much.
Next, we have Madison Beggs. Madison, we saw you walking before, so it was making me dizzy.
Morning. Good morning, Representative Sanchez, ranking members, and members of the Labor Committee. My name is Madison Beggs, and I'm a New Haven County State Marshal. I was appointed by the State Marshal Commission on October 18th of last year, and I'm here to speak in support of Bill HB-5856, and that concerning State Marshals' health benefits. And I apologize, I am outside. I'm in front of the New Haven County Courthouse because I'm on restraining order duty today, so accepting these restraining orders from victims of domestic violence. During my appointment process, I saw other qualified applicants drop out of the race, and due to the fact that the state does not offer any type of health insurance or health benefits for the marshals. I myself was actually met with many puzzled looks and confusion when I explained to others that the job I was working so hard to get didn't even offer me health insurance. As I reflect on what it cost me to become a marshal, I'm honestly amazed that I stuck with it all the way to the end. It was an 11-month process that cost me personally time and money. So when I see the data showing that the marshal community is made up of primarily white males, I'm not surprised. Because my question is, why or how would a single mother or person of low income ever sacrifice money, time, and an effort to get a job that doesn't even offer health insurance? I know that the state of Connecticut values diversity and equality, and this bill is very much needed. HB 5856 will make the job of a state marshal attractive and fair so that people of all races, genders, and ethnicities will be able to get in. Even though I've only been a marshal for 4 months, I've already experienced many late nights and dangerous situations, knocking on doors with flashlights to serve restraining orders and civil protective orders. As you can imagine, I'm often met with opposition while serving these orders. Recently, while I was serving a full protective order where the applicant and the respondent lived in the same house, I was forced to call the police to ask for backup because of the threats that I was receiving from the respondent inside the home. Let me be clear, this is a dangerous job, but it's also a necessary job for the safety of domestic violence victims and to provide the people of Connecticut their constitutional right of due process. As a father, it would bring myself and my family a great peace of mind to know that if I was ever hurt while carrying out my obligated duties as a marshal, that the state of Connecticut would ensure the health of one of its marshals. And so I urge the committee to make this change for two reasons. Number one, so that people of all races, genders, and ethnicities would desire the job of a marshal. And number two, so that the marshals who currently serve the state of Connecticut would have the appropriate healthcare coverage for carrying out their obligated duties. Thank you for your time. I ask for your support of HB-5856, and I'm happy to answer any questions that you may have.
Thank you for your testimony. I just want to make a quick comment because, you know, I've been on the record in terms of other first responders, other persons who really protect our communities. And you, of course, and your colleagues are in that category. I've been on the record before, you know, advocating very strongly for workers' compensation for our firefighters. And when I've heard your stories today, I must say I am really shocked that you are not covered for workers' compensation. That just seems unbelievable to me. So it doesn't lessen my, you know, interest in hearing about your health insurance concerns, but I really do feel like we as a state have a responsibility to make sure that people that we employ to carry out the necessary work and dangerous work that you're engaged in, it's unbelievable to me that you don't have workers' comp. And so I assure you that's something we're going to be looking into as well. Representative Acker.
Thank you, Madam Chair. Madison, thanks for testifying. And Sharon, I apologize for not asking you this. I didn't think of it till just now. Are you considered then specifically a independent contractor? Oh,
Well, actually, we're compensated.
Go ahead.
Sorry, we are compensated as independent contractors, but we're the legislation actually sets our fees, our rates, and we're obligated, like I said today, to be here to accept restraining orders and civil protective orders. So though we have the function and sometimes of an independent contractor, we are regulated by the state of Connecticut.
And are you paid by anybody other than the obligation that the state of Connecticut puts on you?
Yes, we also can be hired by also self-represented people or law firms who would like to hire us to serve civil process for them as well. So a huge portion of it is the state of Connecticut. And also there are others who hire us to do civil process, serve civil process as well.
Okay, and then you don't have to answer this question. I was a self-employed individual. Not proud to say it, but for about 10 years, my wife and I could not afford health insurance. And so we just, do you have health insurance? And again, you don't have to answer that if you don't want to.
Yeah, so currently, as I speak to you today, I don't have any type of health insurance just because I can't afford it. And my wife and my kids are on just because I meet certain threshold, they're on, you know, Husky and the Husky insurance just because I can't afford to get other plans.
All right, stay safe out there and thank you. Thank you, Madam Chair.
Thank you. Representative Wilson has a question.
Thank you. Is it still there? Thank you, Madison. Again, for the testimony. Small question. Can I ask your age?
I'll be 28 in March.
Okay. Thank you. And I asked that question. I'm a young individual myself, so I understand exactly the sacrifice that you're making. This is a large sacrifice. And you being a recent individual to go through the training, could you tell me, knowing that the health insurance is one portion of an issue, what were some of the other, or give me two other issues you would say you had or you could see as a concern for younger individuals or new state marshals going through, knowing of the risk that you're putting yourself into and not having that coverage going into the field?
For sure. Yeah. I think, as I look at the market today and just being a young man, I can look around and I could, easily go grab another job somewhere else that would immediately give me health insurance, other benefits, like workers' comp, also paid time off. We're not offered any of that with this job, but we are regulated and obligated to do certain things for the state of Connecticut. So for me, just looking at, people of my age group, when I offer this job or I, explain this job to them, they're very confused because they're like, why would I get a dangerous job where I could be hurt? And then on top of that, have to cover all the health, medical bills, and I don't get any time off and I don't get, workers' comp. So it's a multiple different things I think would discourage people from trying to pursue the job of a state marshal, and so I think what we'd like to see in Connecticut for the marshals is just that, that open invitation, creating a job that's competitive for other jobs so that young marshals continue to come into the system and serve the people of Connecticut.
Thank you again. And again, I think the same point that Senator Kushner has made. This has been an eye-opening experience for me to really understand really the breadth of all of the other issues that, this is just the tip of the iceberg with some of the things that you guys put yourselves into. And that, beyond just even the health insurance piece, we were talking workers' compensation and all of these other small pieces. So I want to say thank you again, like I've said to the others, for the work you do here in Connecticut.
My pleasure. Thank you so much.
Thank you. I think that's it for now, and we'll move on to the next speaker, Stephen Tomzik. I might not have said that name correctly, but I see you're here.
Yes, hi. Greetings, Senator Kushner, Representative Sanchez, members of the Committee on Labor and Public Employees. Thank you for the opportunity to testify in support of Senate Bill 151, an act establishing a full employment trust fund. I'm Stephen Monroe Tomzik, a faculty member who teaches and conducts research on social welfare policies and programs at Southern Connecticut State University. Today, I come before this committee representing two organizations concerned with this legislation, the National Jobs for All Network and the Social Welfare Action Alliance Connecticut chapter, a progressive group of professional social workers, allies, and community activists. These groups and others have come together as part of a Jobs and Human Rights Task Force to promote a human rights perspective on employment in the state of Connecticut. There is no more important right, in my view, than the right to participate meaningfully in society's productive system, as this allows, as Abraham Maslow might say, for humans to fully self-actualize, that is, to develop an actuality what they are potentially. Intuitively understanding this, nearly 80 years ago, President Franklin D. Roosevelt included the right to useful and remunerative work as the first of the provisions of his Economic Bill of Rights, announced in his 1944 State of the Union address. Unemployment negatively affects far too many people in this state. As of October 2022, over 81,000 Connecticut residents were unemployed. Further, if all those actually out of work or who were employed part-time and voluntarily were counted, this quantity would be over twice as much. As a result, there are many harms for these individuals. Research shows that people who have experienced longer periods of unemployment have poorer health. Additionally, unemployed individuals are at higher risk of depression, anxiety, and other mental health issues than people with jobs. In addition to its negative impact on individuals, unemployment harms the economy of the state in a number of ways. Research has shown that it increases economic inequality, contributes to social exclusion, and inequity for groups that are marginalized. It contributes to greater instability and lowered tax revenues for government services, as well as lowered overall productivity due to the exclusion of these individuals from employment. A policy such as SB 151 will go a long way to addressing the problems caused by unemployment at both the individual and societal level. As a colleague and I wrote several years ago, full employment policies help reduce poverty, increase wages, and given that it will likely reduce inequality, it should lead to a reduction in many of these social ills associated with increased inequality, including mental health, educational performance, as well as potential reductions in teenage birth, violence, and incarceration. Finally, full employment not only aids the unemployed, but it benefits the state's population generally through the goods and services that are created by these formerly unemployed workers. In closing, then, this bill, by establishing a full employment trust fund in order to create employment opportunities and job training programs, has the potential to be an historic achievement for the state of Connecticut, as it helps establish the legislative infrastructure for eradicating involuntary un- and underemployment in this state. For all of these reasons and more, I urge you to pass this important legislation out of committee, including some of the revisions suggested by my colleague, Dr. Philip Harvey, and then champion its enactment on the floor of both chambers. Our state should do no less for its residents. Thank you for the opportunity to testify.
Thank you. And let me just see if any of my colleagues have questions. I don't see any hands. As happens often, you are one of several who have testified on this bill. And so a lot of questions have already been asked, but we thank you for taking the time to be here today.
Thank you very much for the opportunity to testify.
Great. So next we have Shireen Corbett. If Shireen is, I don't see her logged in. So we'll go to Marion Britton. Also, I'm not seeing her. John O'Connor. Kimberly Hart. Suzanne Corbett. You got lucky there because a whole bunch of people were not on remotely. We got to you much quicker than you probably expected.
Good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor Committee. My name is Suzanne Corbett, and I've been a Connecticut State Marshal in Litchfield County for approximately 22 years. I am here in support of HB 5856, an act concerning state marshals' health benefits. When I was hired, I was an emergency hire in our county as there were 2 other marshals retiring. At that time, there was only 1 other woman in my county. I had 4 young children, thought this position would allow me to have a flexible schedule to care for them. In reality, being a marshal is a job that has you working all the time. There have been many times when being in an all-male field was challenging, but I've worked hard and overcome many obstacles. I'm here to speak on some of the dangers we face as marshals, hoping it becomes clear we need to provide health benefits for marshals. There was one instance when I was serving a simple divorce complaint. The defendant was expecting me at the home anytime after 4 p.m. The property was in New Preston, Connecticut, a place where cell service is extremely scarce. Upon arrival at the home, I pulled into the driveway and back into a space in order to easily leave. When I went to the front door, I was greeted by the wife, who was the plaintiff in the matter. She then told me that her husband was up on the 2nd floor with a gun aimed at my car. She said he had every intention of shooting me, but because I was a woman, he decided to wait. I was able to go to the side yard and call state police. SWAT was called to the property, and I was held there until dark when they could safely approach the home. I was taken off property through a river and down a mountain. Total time on property was 5 hours. My family had no idea where I was. When I finally arrived home, my husband told me he no longer wanted me to do this job. He said nothing was worth my life and safety. Every day, every of us goes out to do our job. We never know what might happen to us. State marshals risk their safety for the state every single day. It is shocking for most people to hear that marshals perform a state function without state health benefits. I have done this job for 22 years and have seen relatively few women become marshals. I know the lack of health care is keeping women from taking these jobs. I urge this committee to support HB 5856. Thank you, and I'm happy to answer any questions.
Thank you. And your testimony is very moving. We have, we had some discussion. I certainly, and I know my co-chair, Representative Sanchez, we had some discussion about this bill when we first saw it, and really questioned, how does this really fit in? Is this really necessary? And I think we had come to some conclusions already that this was an important bill to hear. But I must say your testimony and the testimony of your colleagues has been incredibly important today, because hearing the real life stories makes a huge difference in our understanding. And to be honest, there are so many bills that come through our committees. It's really hard to always have to get everything done, to be, frank. But your testimony today and your colleagues' testimony really has underscored the importance of what you're seeking to do here. One question it's funny, you think you asked all the questions, and then you get another question pops into your mind. I have a lot of your colleagues, and you've testified that you work all the time. And I think that's something we haven't really gotten across yet. When you say you work all the time, what does that mean? Like in terms of the amount of hours you might work in a week or a month? Can you quantify it, or days? Maybe?
I can't, I can honestly tell you, probably all of us work about 7 days a week. Our phones go all the time. We're available by cell, by office. And a lot of us have our offices in our homes also. So not only do we do service of process where we're on the road all the time, we also have to go back to our offices and process all that work and answer phone calls and answer emails. Simply, I'm up at about 5:30. I'm on my emails by about 6. So I can try and get out the door between 9 and 10. And then my day is full. Sometimes I can have a short day. Most of my days I'm home around 5, 6 o'clock. My husband will tell you that it takes a lot on us. As we've said before, we don't get paid vacation. We don't get paid sick time. So we need to work. We need to work. We need to answer that phone because that's our living. And we're doing it 24/7.
Wow. So I think that's really important to get into the record, because I think we may have been led to believe that these were jobs that people would take and maybe work 1 day a week or 2 days a week, but it sounds like it's a lot more than that.
Certainly is.
Thank you. Thank you so much. Representative Ackert.
Thank you, and thank you for being here and advocating for you and your colleagues. Just a follow-up question in terms of how much you do. Now, the state requires you to act, right? That's not an option. Is that, or is there another state marshal you can't do it? There's another state marshal that can pick up if something is, you're not available, say. How does that, can you tell me a little bit about that?
Well, when we go from county to county, so if I get a phone call where I'm not available, I basically say, I'm sorry, I can't help you, but we have lists that are through the judicial websites where all of our phone numbers are available. We're designated by county. So that's basically the way that will work.
And then it was mentioned by Madison that he'll do some work for private. In other words, an attorney or something like that. Is that similar in how that's reacted? If you have certain attorneys that may specifically call you, or they go through a list?
A lot of us do have clientele that we've built up through the years. As I said, I've been doing this for 22 years. So I've had a lot of the same clients for 22 years. But it is amazing, as the less marshals we have, then the more work that comes our way, which is a good thing. But that makes us work even, more to be available for everybody who needs our help.
Thank you. Thank you again for being here. Thank you, Madam Chair.
Thank you for your testimony.
Thank you.
And thank you for what you do. Next, we have Heather Longo Raciot. Did I get your last name correctly? I know you're on the Zoom, and if you can turn on your camera too, if that's possible. There you go. Okay.
Hi, good
Let's
afternoon.
pronounce your last name, is it?
It's okay. It's Heather Longo Rassicot.
Rassicot. Thank you. Go ahead. We can hear you.
Good afternoon, Labor Committee members. My name is Heather Longo Rassicot. I'm here before you to speak in favor of House Bill 6721, an act concerning workers' compensation coverage for 911 telecommunicators. I am currently employed as a part-time 911 dispatcher for the towns of East Lyme and Waterford. I have over 23 years of service as a 911 dispatcher. My experience is both in full-time and part-time. In addition, I have over 25 years of service as a volunteer firefighter EMT. During my employment as an essential employee in my role as a 911 dispatcher, I've been required to report to work during times of severe inclement weather, during periods of time where roads were closed due to hazardous conditions, during states of emergency declared by the governor, and prior to the town and state highway department's response to treat and clear the roadways. I recall a specific commute in the fall of 2011 during a hurricane, driving to work with trees and limbs falling into the roadway, streets flooding, and the wind was so strong it blew a portable shed right into my path of travel on the road. 911 dispatchers are the first link in the chain of survival. When a caller dials 911, they are connected with a 911 dispatcher trained to handle and initiate the mitigation of the reported emergency with care and attention to detail, with the safety of the public and first responders as a top priority. The critical services provided by fire, police, and medical are able to respond to aid the communities they serve due to the diligent and professional work by the 911 dispatchers. 911 dispatchers should be afforded the same protection of portal-to-portal workers' compensation coverage as their brothers and sisters in the fire and police department. I urge you to please support House Bill 6721. I thank you for your time and available for any questions.
Thank you for your testimony. We did have some testimony in opposition earlier today, and from someone who is involved in the workers' compensation insurance program. And I asked her, and she didn't know the answer to the question, so she'll get back to me. But I'm curious. I've heard from you and your colleagues that you want to be treated the same as other first responders. You're part of the team, and you should be paid in the same way or compensated in terms of workers' compensation in the same way. So she testified that currently, if you are called out for an emergency, you would be covered portal to portal. Is that your understanding?
It's my understanding that that is depending on potentially any negotiated contractual language that would support that. I know that at my places of employment for any scheduled shifts, I am not covered portal to portal.
On any scheduled shifts, but what about when you're called in for an emergency?
I am not covered in East Lyme or Waterford if I'm called in.
Okay. And are you aware, are fire and police officers, are they covered portal to portal in situations other than an emergency?
It's my understanding that they are, and it is also, although in a capacity of operating during an emergency, as a volunteer, I am also covered during that time.
Okay, that's very interesting. All right, thank you for your testimony. Any other questions? Okay, thank you for being here today.
Thank you.
And the next person on the list has the same last name. I wonder if you're related.
It is my husband. Can I have him switch seats with me, or do you need him to log in under his own?
You can have him switch seats. We'll make it easy for you.
Thank you very much. Hold on one moment.
Sure. Oh, he's getting in the back seat. This is the wonders of Zoom. Thank you, Lou. As soon as you're ready, you can unmute. We can see you, but you're muted.
Okay, there we go.
Great.
All right. Lou Rassicot, East Lyme, Connecticut. As a first responders are a broad term defining police, firefighters, EMS. The current legislation covers firefighters, police officers, portal to portal, to and from work. The dispatchers deserve the same coverage as their duties are just as critical to the response of emergency services within their communities. Because dispatchers are considered essential personnel, they often may encounter hazardous conditions traveling to and from work, not limited to weather conditions and their requirements to travel when other non-essential employees may have to stay home. Dispatchers they're an important first link in the response to an emergency. They answer the frantic calls, quickly gather information, documenting what they need for essential response to get the proper resources out to the emergency. As a career firefighter and a part-time dispatcher, I realize the importance of this position and their requirements to be at work regardless or without delay. This bill would afford the dispatchers the same coverage and compensation security as firefighters and police, which they deserve as essential employees. That's all I got for.
That was enough, and it was well said. We have heard from several of your colleagues today, including your wife. And so you all have done a good job of bringing us awareness about the issue that you face. I will ask if any of my colleagues have questions. I don't think there are any questions for you today, but we appreciate you being here. And you did.
Thank you.
I heard Representative Ackert say this. I think this is the first time we've seen people change seats. We've seen people in houses speak from the same Zoom link, but this is great.
It's the beauty of Zoom.
Absolutely. Thanks so much for being with us today.
You're welcome.
Next up, we have Joe Samataro. Is Joe with us? I don't see Joe. Oh, there you
Yes,
are.
yes.
Go ahead, Joe.
Thank you. Good day, Labor Committee members. My name is Joe Samataro. I'm here to speak in favor of House Bill 6721, an act concerning workers' compensation and portal-to-portal coverage for telecommunicators. I currently work as a public safety dispatcher for the Department of Emergency Services and Public Protection. I'm a member of AFSCME Local 610, whose membership include public safety dispatchers throughout Eastern Connecticut. I have 33 years experience in public safety dispatching, nearly 20 years with Connecticut State Police. And prior to state service, I worked as a fire and EMS dispatcher for municipalities in southeastern Connecticut. As you're aware, public safety dispatchers work 24/7, 365. 911 calls for assistance from the public are answered by dedicated dispatchers. We are the first responders. The fire departments, ambulances, and police services would go nowhere if not for dispatchers. Life-saving pre-arrival instructions are provided to callers by dispatchers. We are always there to answer the call, and because of that, we are required to report for duty regardless of weather or travel conditions. I have traveled to work in all weather conditions New England has to offer, including blizzards, ice storms, and even hurricanes. When the roads are a sheet of ice before treatments are applied, I come to work. When highway travel is restricted, I come to work. And when the governor closes the state and all other state employees stay home, I come to work. Please know I'm not here to complain. I'm fiercely proud of my career and the dedicated men and women that I work alongside of. But while our police officers and firefighters enjoy the benefit of portal-to-portal coverage, my colleagues and I do not. Although my employer requires me to drive my personally owned vehicle to work regardless of the danger, I am not afforded the same protection of workers' compensation should something happen to me on my way in or my way home. When I was assigned to a barracks an hour away from my home, I watched as dispatchers slept in a coat closet after being ordered to work double shifts with a short turnaround during severe winter weather conditions because they were so tired and travel was too dangerous. I've seen dispatchers sleep in their vehicles in the parking lot rather than risk being in an accident. And last, one of my colleagues was injured when his SUV rolled over during an accident on his way home after a double shift. He was not covered by workers' compensation. Sadly, he has left the profession shortly after. As a public safety dispatcher, I'm also subjected to being ordered in to work shifts. I can be ordered to stay after my regularly scheduled shift, regardless how tired I am, and I can and have been ordered to come in because of impending severe weather, and yet I'm not covered by workers' compensation during my commute. For these reasons and many more, I ask that you support House Bill 6721, and thank you for your time.
Thank you so much for your testimony here today. We have heard from a number of your colleagues. And so we've asked them a bunch of questions, and I don't see any. Oh, Representative Ackert.
Joe, thank you. During your testimony, you mentioned somebody gets the portal and you don't. Who was that again?
The police officers and the firefighters that I dispatch are covered portal to portal by workers' comp, and I'm not.
When they're in their personal vehicles?
When they're in their personal vehicles or when they're in their state vehicles, depending if we're talking about a municipal department or our state troopers.
Thank you. Thank you for that update, that follow-up. Thank you, Madam Chair.
Thank you for your testimony here today. So we will move on to our next speaker. I'm looking for Todd Goodhind. Is Todd here? Yes, Todd, there you are. Thank you. Go ahead.
Hi, good afternoon, Labor Committee members. My name is Todd Goodhind. I reside in the town of Waterford. I have over 35 years of service in emergency telecommunications as my partners before me. I believe the portal-to-portal coverage is essential for 911 dispatchers. Over the years, I have driven through rain, snow, hurricanes, and so much more. As previously stated by Joe, I've also slept at work, regardless of what the conditions were, due to short turnover, whether it's a concern of weather or other reason. My family understands my job. They understand it's important, but they share the concern for my safety in traveling to and from work. This coverage would afford me and my fellow 911 dispatchers the needed protection should something occur to us during our commute. We travel at all times of day, evening, and night to perform our job. If something happens during my commute, I would have to rely on my sick time, if I have any. Being that currently I work part-time, I'm not afforded that. I've recently retired after 27 years of service to my municipality in a full-time position. The sick time would allow me to help my family. However, the portal-to-portal clause would take and benefit our family and my coworkers should something happen. The coverage is afforded, as previously stated, to police and fire personnel, however, not 911 dispatchers. Without the public safety dispatchers, there would not be a link for the public to reach the needed services they require. We are the voice in the dark. We are 911. Thank you for your time today. If anyone has any questions, I'll feel free to answer them.
Thank you. And thank you for your testimony and thank you for your service. I don't see any questions or comments at this time. So we will move to the next speaker, Monica Nugent.
Hi, good afternoon, everyone. I apologize. I'm volunteering at my daughter's school today. So if you hear some rogue children in the hallway, that's the background noise. Good afternoon, Senator Kushner, Representative Sanchez, and members of the Labor and Public Employees Committee. My name is Monica Nugent, and I am a manager of the Judicial Selection Commission and the president of Managerial and Exempt Employees United, a local of AFT Connecticut. I'm here to offer testimony in support of House Bill 6720, an act concerning the state managerial employee definition for purposes of collective bargaining. Through the advocacy and the work of this committee last session, sorry, just give me 1 second. Through the advocacy and work of this committee last session, we were given some of the same access to wage provisions in the CBAC agreements of other employees in state service. Despite this big step in the right direction to solve compression and inversion in the managerial class, there continues to be inequities in both the benefits and the rights that are given to managers in state service. This bill, which follows the same definition as the higher education system, would allow more groups of employees access to collective bargaining and therefore better access to certain rights and benefits. There are many examples of these inequities, but I have a couple to highlight below. First, there's no mechanism for a manager superior to request that a manager receive a raise for merit or other reasons. Performance reviews throughout the state for managers that dictate raises have been shuttered. There is one process that requires several levels of approval from various state agencies that more times than not ends in a denial. If there is a denial, there is no other independent body or recourse that managers can take, not even the employee review board. Second, the managerial pay plan is not in line with other bargaining unit pay plans. There's no outlined step increases in the pay plan. There is only a range that is offered for a specific level of managers in state service, and you receive pay somewhere within that range. This leads to the third issue, being that new managers to state service are only offered the minimum salary in their pay range. There's no allowance for hiring a manager to offer a salary that may be more in line with the person's education or work background. This has led to further inequities in pay, adding to compression and inversion, but has also added a massive burden to the recruiting and retaining of managers in state service. For example, at least for the next few weeks, I'm still the manager at Judicial Selection Commission, but it has taken over 9 months to hire my replacement, and several people have declined the position due to the salary level. Lastly, managers do not have the same access to training opportunities for professional development, access to a sick leave bank, or access to tuition reimbursement. It is our hope that through changing the definition of what constitutes a manager in the state, more employees will be able to access the rights and benefits that are already being offered to other state employees. Thank you so much for your time.
Thank you. And it's good to see you. I do want to acknowledge all the work you did on the task force that was created by this legislature, and then your work last year advocating for the recommendations of the task force. And I do note that this was one of the recommendations that came out of that work. So I appreciate you being here today. I see Representative Ackert has a question.
Thank you.
Thank you, Madam Chair, and thank you for volunteering with your child's school and all the other work that you do. So just a quick question. So you say when they go to, get a job opening, they go in to discuss, I guess, with hiring, whoever's hiring, that they can negotiate at that time in that pay bracket. Is that not correct?
No. If it's someone that is new to state service, so someone who is coming from private or municipal, so a new state employee, they must enter the job at the minimum state salary level. And the only way that that could be negotiated is to, again, go through a multi-step approval process that basically is a special circumstance. And you have to write a letter to DAS and OPM asking for a higher salary. But there's no, you can't just say, my position started at 69,000. You say, well, I'd really like 75, and they just give you 75. It's another multi-week, multi-step process that is not guaranteed to have that ultimate final number.
So thank you for that answer. So when they DAS, because I've been on their website and looked at the pay bracket, they actually they post a pay bracket. You pretty much, if you're coming new from out of state service, not a lateral move, or you're at that bottom number. Is that what you're saying?
Correct. Correct.
Unless you go through more hurdles to get what you probably deserve.
Right. And so the more hurdles become more problematic when state service already takes a long time to get hired into. So when you have been waiting for 5 or 6 months to come into a position, waiting another 3 or 4 weeks for employment is oftentimes not something that most, at least applicants I've seen, just from my own personal experience in my position right now, that they want to go through.
No, I've heard that from commissioners, the same exact thing that you just stated, that by the time it takes us to fill the slot, they've already moved on to a different job. So, thank you for your testimony.
Correct.
Thank you, Madam Chair.
Thank you.
Thank you for your testimony here today. And I don't see any other questions at this time. Too bad we can't see your daughter. She spent a lot of time on Zooms with us when we were in the task force meeting. So I'm sure she's gotten a little
She
bit.
has. She has, and we actually have a matching outfit on today, so it's a missed opportunity, but we'll be sure to get her on a different day.
All right. Thank you and take care.
Take care.
Next up, next we have Eileen Ego.
Good afternoon, Senator Kushner, Representative Sanchez, Sampson, Representative Ackert, and members of the Labor and Public Employees Committee. My name is Eileen Ego, and I am a resident of Griswold. I work as a district engineer at the Connecticut Department of Transportation. I offer the following testimony in support of HB 6720, an act concerning the state managerial employee definition for purposes of collective bargaining. I support HB 6720 because it will provide collective bargaining and union representation for an important segment of Connecticut state employees. DOT district engineers and division chiefs provide essential leadership for administration of the department's capital program. As a result of the bipartisan infrastructure bill, Connecticut is now a recipient of a record amount of federal funding for bridge and highway improvements. We are the folks that ensure this money is spent responsibly and wisely. We are the folks that maximize the return of federal dollars to the state of Connecticut. We deserve to be treated with respect, and that has not always been the case. In February of 2021, I was offered a promotion to district engineer in the District 2 Norwich office. I would be the first female to serve in this capacity, and after 34 years of dedicated service to the department, I was looking forward to the new challenge. Unfortunately, due to salary inversion issues, the promotion actually came with a pay cut. I was told at the time that I could negotiate my salary and tried to do so, but my proposal was denied. In July of 2021, Governor Lamont recommended several steps to address salary compression and inversion issues among state managers. Over the next year or so, data was collected and some minor adjustments were made. None of this helped me, though, as I was at the top step of my pay grade. In November of 2022, during a monthly meeting of MAC, I became aware of the Employees Review Board. It was presented as an opportunity for managers to seek redress on grievances they might have. I immediately submitted a package addressing my de facto demotion. It was not long before I became acutely aware of the limitations of this process. First of all, most managers are completely unaware of this avenue, as was I originally. The deadline for appeal is extremely tight. In most cases, you're required to submit your appeal within 7 days of the prior decision. However, it takes several days for you to receive the decision. I just completed level 3 of this process and had less than 24 hours to prepare my appeal and get it physically to the review board in Hartford. Also, the jurisdiction of the Employees Review Board is very narrow. You basically have to demonstrate that a law has been broken. I was informed that the board has no jurisdiction over matters of fairness, as my situation was defined. So where is a manager to turn for matters of fairness? If we were able to bargain collectively and had the associated union protection, we would have advocacy in such matters. HB 6720 will allow for us to collectively bargain. I urge you to support this legislation. Thank you for the opportunity to testify, and I'd be happy to answer any questions you may have.
Thank you for your testimony. And I, as in other cases today, hearing directly from people who've been impacted by the system that we have in place currently makes a huge difference to us. It really does. You put a face to it, you hear a personal story. You've accomplished so much in state service. You've served for so long. It really, it makes it hard to understand why you wouldn't have more rights at this point in your career. And hopefully we can address that in this committee. So I don't have any questions. And Representative Wilson has a question.
Thank you. Thank you again. Mine would be a small one. I know we talk about the process, the length of time it takes for hiring, just as the previous person highlighted. And I know, one of the other concerns in certain professions has, we've talked about diversity but also an opportunity for women when it comes to promotions and things of that sort. So, currently, such a thing. Do you think this is becoming a bigger deterrent in your area, your field, for women to have an opportunity to elevate to different levels?
I absolutely do. I absolutely do. First of all, there's an awful lot of competition in general for folks with our credentials. The consultant community is hiring an awful lot of folks. The reason I got the promotion was my predecessor left state service 5 years early to receive 50% more compensation, and he's like in charge of one project. He's far less responsibility than I do, and he's making 50% more than I am. So yeah, so I mean, in general, it's causing an awful lot of people not to want to take management positions, and certainly women and minority candidates are being recruited just as aggressively by outside firms and private industry. So yeah, it's definitely I would say definitely affecting the diversity in our ranks.
Thank you. And I'm guessing with people not taking managerial roles, this has a trickle effect on some of those other areas where we're needing roles to be filled.
Sure. Yep.
All right. Thank you again.
That was a pretty big question for just a little question. But it was a good question. So thank you so much for your service and your testimony here today.
Certainly. Thank you.
Next, we have Manuel Sandoval. Good to see you, sir.
Oh man. Just happened. I think I ran out of power. Hello, Senator Kushner, Representative Sanchez, Ranking Member Sampson, Ackert, and distinguished members of the Labor Committee. My name is Manuel Sandoval, a resident of New Britain and an ACLU Smart Justice leader. I'm here to support House Bill 5033, an act concerning the compensation of incarcerated individuals. I want to thank Representative Rosario for introducing the bill. Due to my mistakes, I was incarcerated, struggling to make ends meet and not wanting to burden my family. I worked for DOC for $125 a day. I understand everybody loves a good deal. However, let's call it what it is: slavery. Our government has continued the atrocious labor practices started by our forefathers centuries ago. They continue to perpetuate slavery by using it in incarcerated individuals as currency. Yes, we are slaves. Our government has chosen to alienate, disengage, and incarcerate its already vulnerable population, the Black and brown communities, the ones that for decades have dealt with redlining, predatory lending, homelessness, and family disassembling. Why? Because they can, too often using the Black and brown population as a stepping stone in the process. Using the 13th Amendment, our country has managed to circumvent the anti-slavery laws and has continued the practice of owning slaves. This includes Connecticut. Its incarcerated people are highway janitors, highway cleaners, librarians, cooks, and any other position completed by an inmate. The difference being we're paid pennies on the dollar, slave wages to be exact. To compound this, Connecticut has the audacity to charge for previously incarcerated people for room and board upon gaining a windfall of monetary funds. The state can legally take money from people's inheritance and lawsuits, even if they were harmed in prison by the state. I know this is irrelevant, but it's something to think about as it mostly affects Black and brown communities. I find it appalling that Connecticut continues to practice using slaves. I guess that's why it's easy for them to deny them adequate medical care, real mental health care, decent meals, family support, or any kind of human decency that one deserves while being incarcerated. Instead, our state releases this population upon completion of their sentence into poverty, without nutrients or shelter of any kind, without the support of loving relationships that can increase this success. All this in the name of it's good for the people. What's worse is that upon release, we are expected to work and pay dues. We're expected to participate in a world that we are not wanted in. Despite our attempts to better ourselves, we are expected to pay taxes, taxation without representation. Instead, our government infringes upon its second-class citizens, the Black and brown population, and worse, the previously incarcerated. I've been blessed that since being released, I found employment. I found it necessary. I made the necessary changes. However, not everyone has these opportunities. That's why this bill is important. Providing people with the opportunity to earn is an opportunity at a sense of dignity, which many people may never get because of the barriers in place. Thanks to last year's bill 5248, which started in this committee, I became a licensed clinical social worker at a community mental health organization. Our government insistence on creating barriers instead of opportunity has me unemployed again. Taxation without representation at its finest. I will not be allowed to practice unless the government removes me from an exclusionary list I knew nothing about. How awesome is that? Licensed and can't even use it. But I better not forget to pay my taxes. House Bill 5033 is a step in improving labor conditions and wages in Connecticut prisons. However, this legislature should go further and increase prison wages to a minimum wage. Be the change. Ensure that previously incarcerated populations receive the needed support upon their release by being able to care for themselves, even if they are alone in the end. This is why I support the bill and ask you to support it as well. Thank you.
Thank you. Thank you, Manny. Excuse me. First of all, your advocacy is so appreciated, and I've seen you here many times over the last several years, working hard on behalf of formerly incarcerated persons and incarcerated persons. And I think that's really important. We had testimony earlier by Representative Rosario, who introduced this bill. I think that this bill has made us much more acutely aware of the unfairness regarding wages. And I think that's something that, most of us were really not tuned into at all. So once again, you and your colleagues have really brought forward something that is very important for the legislature to hear. I do want to say that, your perseverance pays off. And I wanted the committee members to know that both of my colleagues who are here today, as well as Representative Sanchez, I think Representative Sanchez was here at the time. These two colleagues were new to the committee, aren't aware about the bill that you referenced that we passed. And as a result, you have been licensed as a licensed clinical social worker. And I just wanted you to see, I do have the picture that you gave to me and the copy of your license. I keep it on my desk upstairs. Really, the work we do here impacts so many people's lives, and you're one of those people. And we couldn't get this done without your advocacy and your willingness to be here and testify. So I appreciate it. I can assure you the bill that was submitted by Representative Rosario is going to get very diligent consideration by the committee. And I think that speaking for myself, and hopefully other committee members will agree, that we were unaware that Connecticut pays some of the lowest wages in the country, let alone probably the lowest in the Northeast, to incarcerated persons performing service and performing work. So it's really important what you do here today. So Representative Ackert.
Yes, thank you for being here. You covered so much in your testimony, a lot. Are you aware, as I brought up to Representative Rosario, that Connecticut charges for those that are incarcerated that go out and serve the public, charges those entities a fee to have them do that work?
I'm not, not entirely, but I assume that's what it was, because I remember they said something about the sewing department used to make X amount of money for making apparel, but they never really, it never came back in. But I'm not sure. It was just hearsay, so I couldn't really say that it was real or not.
Yeah, I'm going to inquire what the state does after this testimony. I should have done it back when I was working at the fair, and was kind of shocked that that state actually charges for individuals to go out And I get it, there's a cost to, you know,
Mhm.
to bring people, the sheriffs, but they have to work anyways, right? They're already work, so they're just getting out also. So I'm gonna look into that and see what this revenue gain to the state and the Department of Corrections is on the behalf of inmates. So thank you for being here.
Thank you.
Thank you, Madam Chair.
Representative Wilson.
Thank you. Just one small question. I kind of asked it to Representative Rosario, but an individual who has been in the shoes, having the pay increase in the prison. Just your opinion, what does it do to individuals when we talk about recidivism rates and things of that sort? How does it help them put them on a level playing field when they get out?
Okay, so let's say an individual gets the minimum wage that we have now, right? That person has no expenses at this current time, right? Except for being incarcerated. So they can, you know, you can set them up with some kind of banking system where they can allocate all that money accordingly. Say, for instance, you could put X amount of money for your rent expenses that are going to be coming up upon your release, right? And you put X amount for the miscellaneous, right? Which if you teach them, because a lot of the people don't have the financial stability, don't have the financial education, right? And this is stuff that we need to learn as it is, right? But if you could teach a person that is going through this process how to do all this, you're teaching them to be successful in the long run, right? Because now you have them, you know, their housing taken care of, their miscellaneous taken care of, and now when they come out, they're not homeless. I mean, when I was working for the entity that I was working for, right? I was working with the homeless population, and more than half had some kind of legal experience, right? They have been incarcerated in something, and they come out and they have nowhere to go, right? We can't go to public housing because Section 8 refuses to, you know, have us there, right? So if you have some kind of funds that you can put towards the housing, and then, you know, everything else starts to fall in place, because at the same time, the connections you're making while incarcerated, you can also use, let's say, if you can use them as references, right? These are things that we should be assisting those who are going to be coming home with making those. Listen, social capital is one of the biggest things you have. And you, more than anyone, knows that. You know, you have a social capital. That's money in your bank. You need that person to back you, they're going to back you. If they don't like you, then they're not going to back you. All right. And stuff like that. So social capital is big, and the actual funds is big. So we need to be able to teach them all of that.
And the reason I asked that question, you kind of already answered the second piece to it, which, you know, it sets an individual up to also be less reliant and being on a waiting list for possible housing, medical services, but it also allows them to get back with or to their family or the members in their community much quicker in a much more stable manner. So I appreciate exactly that point.
Thank you. I guarantee you that if half the people that came home had a stable place to live, a decent place to work, and not feel like they were being taken advantage, you wouldn't see the recidivism that you have. You wouldn't see it, because people want to be home. They don't want to be in there. You know, they want to be around, surrounded by people that they love, and making money and being able to be just giving back. Because believe it or not, people want to give back to the community. Is like, you know, you make a mistake as a young person, and then you wake up and you're like, oh shoot, I messed up, you know? And then bam, you want to do better and you can't, because they just keep holding you down.
Thank you. Thank you so much for your testimony. And if you wouldn't mind, I don't know if you're going to be around for a little while, but I didn't get to take a picture with you that day because I was running around. So if you'll hang out, we have a couple more speakers here, and then I'll come out, and with your friends, we can take a picture.
More than a pleasure. Thank you.
I
Thank
think
you.
Rep. Sanchez may have had a.
Oh, I'm sorry, Representative Sanchez. You know,
No problem at all. I just wanted to say hello to Manny and thank you for all of your advocacy and all of the work that you've done. I've known Manny for over 15 years, and the person that you're seeing today is somebody that he's always been, and he puts himself second almost all the time. So Manny, just thank you Thank you all. Thank you for
Thank you.
so much that you do.
Thank you. I appreciate you. Appreciate all of you. Thank you.
Thank you. Thank you. So we have two more speakers today. So we will move to Kathleen Callahan.
Powerful. I'm not ready to talk right now. Thank you, Manny. Dear Honorable Chairs, Kushner and Sanchez, ranking members, vice chairs, and all other members of the Labor and Public Employees Committee. My name is Kathleen Callahan, a resident of Stratford. I am testifying on behalf of the National Association of Social Workers, Connecticut chapter, and we call upon the committee to support SB 151, an act establishing a full employment trust fund. Employment plays a pivotal role in an individual's economic and social mobility. The legislative approaches we seek address community needs to reduce economic disparities related to the accumulation of wealth or cycles of inescapable poverty. And this bill is positioning Connecticut as a leader. Our state can provide equitable access to resources and the potential for livable wages for all job seekers to move Connecticut toward full employment. As social workers, we have the honor of counting Frances Perkins, FDR's Secretary of Labor, in our ranks. On February 25th, 1935, 88 years ago, almost to the day, she gave a radio address to the country about the administration's draft economic security bill. And I quote, "Recognizing unemployment as the greatest of all hazards, the committee gave primary emphasis to provisions for unemployment, employment assurance. Employment assurance, the stimulation of private employment and the provision of public employment for those able-bodied workers whom private industry cannot yet absorb, is to be solely a responsibility of the federal government and its major contribution in providing safeguards against unemployment." End quote. SB 151 would create the workforce we need in Connecticut today and raise wages throughout the state, similar to what New Deal programs did during the Great Depression. Job creation helps jobless people and industry in need of workers, of course. It also helps community. Individuals and family have the possibility of reducing debt, saving, and investing. Small businesses have more customers. Startup companies have more investors. Workers have bargaining power to demand fair wages. Consumers have power to demand lower prices. And every individual, family, community has the value and dignity that comes with having a job with the means to plan for the future. Racial inequity of employment exists, with rates for Black workers historically and consistently twice that of white workers, regardless of education attainment. This is specifically disturbing when white workers with less education are employed when higher educated Black workers in desired fields are not. Beyond an individual's prospects in the labor market, research details the lifelong consequences of unemployment or underemployment, including but not limited to increased rates of physical and mental illness, substance misuse, domestic violence, failed relationships, and suicide and attempted suicide. In closing, I look toward our future. We're living through multiple interconnected crises: pandemic, systemic racism, climate change, opioid overdoses, youth suicidality, and punishing economic inequity. Which has been the only experience for our youngest residents. For far too many of our disconnected opportunity youth in the state of Connecticut, this bill can be the start of restoring their vision for life. NASW Connecticut urges the committee to pass SB 151 out of committee and allow the full Senate to begin debate on Connecticut's economic vision for tomorrow. With respect and gratitude for your service and consideration.
Thank you for your testimony here today. You are one of many that have testified on this bill, a bill that we really didn't know we didn't know this was something that we should be thinking about. So we really appreciate the number of people that have come out today, you included. I don't have any comments or questions at this time, so I will move to our final speaker for today's public hearing, Pat Farley.
Hello. Good day, Labor and Public Employee Committee members. My name is Patrick Farley. I'm here to offer testimony for House Bill 6721, an act concerning workers' compensation for portal-to-portal coverage for telecommunicators. I am employed by the Department of Emergency Services and Public Protection as a public safety dispatcher. I've been employed for 13 years. Prior, I worked at another agency for a total of 17 years in this profession. I'm a member of AFSCME Local 610, which covers dispatchers in the eastern part of Connecticut. We're seeking support for this bill to cover us under workman's compensation to and from work. We work in a profession that requires 24/7, 365 days coverage. We work in snowstorms, hurricanes, when the state roads are closed, and when a state of emergency is declared. We have to show up for our shifts and provide a vital role in public safety. We're asking for coverage if something happens on our way to or from work. The same coverage is awarded to our fellow public safety employees, police and firefighters. They're covered and we're asking for the same. We're not complaining, we're simply asking for the same coverage. Our role is just as vital as theirs. We provide care for those in a time of need, regardless of road conditions and weather. Our concern is if something were to happen and we were injured on our way to and from work, there would be no coverage for us. Being a father myself, this concerns me, as if I'm out of work for an injury that I incurred on my way to and from work, I would probably struggle to provide for my child. The probability of this happening is much higher with my job, that I have to be there no matter what, any road conditions. We can work long hours, being ordered in from home, ordered to stay for extra shifts, especially if we're notified with minimal notice, add an exhaustion on top of poor road conditions. The probability of an accident, medical condition, or an injury is much higher. For these reasons and many more, I ask for your support in House Bill 6721, and I'd like to thank you for your time.
Thank you, Pat. Appreciate your testimony here today and the testimony of your colleagues, many of whom have already testified. Any questions? I think we've asked all of our questions already to the speakers before you, but appreciate you being here today. So thank you very much.
Thank you very much.
So that looks like we have covered all of the folks who signed up and were here either through Zoom or in the room. So we appreciate the participation of all who've attended today. Representative Sanchez, you're looking good. We hope you're feeling well. And, you know, we hope to see you back here soon as you can. Any closing remarks you'd like to make?
Just
I was calling on this. You don't have your computer on anymore. Let me ask Manny first since he's here.
Thank you, Senator Kushner. I just want to thank all who participated today and testified.
Great. You know, you could tell I was looking right at him. It's so hard with the screen but Representative Acker.
Thank you, Madam Chair. Just that Representative Yakarino was out for due to medical.
Thank you for letting us know. I know that you made the comment, as did Senator Sampson, but for the public's knowledge, we just want to make sure people realize that we've had members of the committee that have been observing remotely, but many of our committee members are in other hearings today. And so they come in and out, but everyone is interested in the testimony and we make sure everyone's aware of what we've deliberated about today. So thank you all for participating in this hearing today. And we look forward to seeing you at the next meeting of the